now in session. Judge Stork presiding.
Good morning, everyone. Please have a seat.
Yeah.
All right, time set for trial in Nelson versus Wade. Let's start with appearances for the record, please. We'll start with the plaintiffs.
Good morning, Your Honor. Paul Friedrich for plaintiff William Nelson. And good morning, Your Honor. For the record, Alexander Sutherland here with Mr. Nelson as well.
All right, thank you. For the defendants?
Good morning, Your Honor. I'm Erin Lane, appearing for the defendant, Houston Wade.
Good morning, Your Honor. Melissa Hulsman. I just appeared to assist Mrs. Lane.
Very well, thank you. All right, so first thing, just a reminder to everyone that all we have to try this morning is the willful prong of Section 523A6, which focuses primarily on Mr. Wade's subjective intent. So as you are presenting evidence, please keep that in mind, and let's not try to stray off into a lot of areas that don't go to that issue, because pretty much everything else in this adversary proceeding, I decided on summary judgment based on preclusion from what happened in the state court. So try to stay focused as best you can on the actual issue that we're trying this morning. Next, at the pretrial conference, we talked about admitting exhibits. You did submit a revised pretrial order, which I entered, which appears to have 6 of the exhibits that the parties have agreed are admissible. So my intention is to go ahead and admit those now unless there is some objection. So, Mr. Friedrich, any objection to the admission of the agreed exhibits in the pretrial order?
No objection, Your Honor. Just to confirm, those exhibits are Plaintiff's Exhibit 1, Plaintiff's Exhibit 4, Plaintiff's Exhibit 5, Plaintiff's Exhibit 7, Defendant's Exhibit 3, and Defendant's Exhibit 6.
Correct. And Ms. Lane, any objection?
No, Your Honor.
All right, then exhibits P1, 4, 5, 7, and D3 and 6 are admitted. As far as testimony, again, we talked at the pretrial conference, we just have the 2 witnesses, but did you talk about the order or how you wanted to present? And what I mean by that is there's really 2 ways to go about it. The plaintiff can present their witnesses and they can cross and then be done, and then the defendant can call the same witnesses and you can do cross and we're done, or else you can just do everything at once, one time with each witness. And I really don't care how you do it, but I'd like to know how you would like to do it. So, Mr. Friedrich, first of all, did you talk about that at all? And if not, do you have a preference on how to go about it?
Your Honor, we did speak with counsel regarding that on Friday, and we thought we had an agreement, but it sounds like there was a little bit of confusion when we met with Ms. Lane this morning. So I probably need a minute to confer to just clarify what exactly are, in fact, our positions on that question, Your Honor.
All right, then I'll give you a minute just as soon as I get through my preliminary things.
Thank you, Your Honor.
Which is the next one. Are there any preliminary things from the parties that we need to cover before we start with the actual presentation of testimony? Mr. Friedrich, anything from you?
Nothing, Your Honor.
All right. Ms. Lane?
Yes, Your Honor. You had on Friday said that if, for example, I'm up questioning a witness, that like Ms. Fieldman could object as well. I'm asking the court to reconsider that. I believe that it could cause a little bit of a circus within the court. I think of whoever is up there asking the questions, that should be the person who should be, I mean, they're the one examining, they should be the ones also to object while they are up there.
Yeah, and again, I kind of waffled on it during the pretrial conference. I said I start that way, but if it does become a circus, I'm going to cut it off. So I'm going to let it see how it plays out, but if we're having any problems, I'm going to tell the parties that's the end, and we're going to just do it the way that you would prefer. But I'm going to let it I'm going to let it at least start that way, and if it becomes a problem, I will stop it. Let's see. I think that's it. Oh, the only other thing, use of the podium for me is optional. I don't require people to get up to the podium, so you can present from wherever you're comfortable. But you do need to be close to a microphone is all when you're talking, because that is our official record. We don't have a in-courtroom court reporter. It's all digital audio. So with that, why don't I give you just a minute to confer about this witness question, and then we'll get started. And for that, maybe just back away from the microphone, actually, if you would.
So honestly,
Yep.
And how are we going to proceed?
Your Honor, the parties have agreed that we will proceed via the first route, where essentially we will call each individual and complete all testimony, cross-examination, and whatnot all at once, and then proceed to the next one rather than have two separate
Okay.
cases in chief. This is being done with understanding that essentially, well, it might go back and forth quite a few times depending on, redirect, considering we are combining the two sides at the same.
What you mean by that is while the witness is up there, each side may
Yes,
question multiple times.
yes.
That's fine. That work, Ms. Lane?
Yes.
All right?
Yeah, I would just add to I think he just forgot that one of the things we talked about was if a witness has already stepped down and the other person's up, but then one of us decides that, or realizes like, hey, we wanted to ask that person another question or something like that, that we would not oppose each other recalling that person for obviously something, limited, not
Yeah.
like 2 more hours of testimony.
Yeah. So, right.
Is that
So
consistent, counsel?
the first person testifies, then the second, and based on the testimony of the second, somebody may want to ask a question again of the first witnesses.
Yeah.
Will allow him to be called back.
Yeah, and I think it was contemplated in a restrained fashion, so it's not opening the floodgates again for hours more, but just like, oh, hey, something came up, or we forgot something, or,
Yeah, understood, and that's what I would expect when we do it this way, so that's fine with the court as well. All right, so let's call a witness, please.
Your Honor, I think we're going to have a very brief opening.
Oh, you want to have an opening? Go ahead.
Yeah, just very briefly, Your Honor.
Yeah, no problem.
I'd be remiss if I didn't give an opening, even though Your Honor said it's optional.
It
Your
is
Honor,
optional.
I'm sorry, before he starts, I
Oh.
thought you were going to rule on motion in limine.
The ones that I didn't already rule on, I'm just going to rule on in the context of in the course of the trial, if they even come up. I've looked at some of these. I don't think some of these are even going to come up, but if they do, I'll just rule on them as live objections during the course of the trial.
The only one that I guess we need clarification on, and obviously I'm new to this, but I've done my best of getting up
Yeah,
to
that's
speed
all right.
on this very quickly, is the admissibility of the deposition transcript that was never disclosed during discovery.
I think we ruled that it's not admissible as an exhibit. We did cover this one, I think.
Okay,
I
I'm
think
sorry.
the transcripts are not admissible as an exhibit, but they can be used for impeachment.
Okay, sorry, sorry. It's hard because I'm talking and she's telling me she didn't understand that. But, sorry, so my question though is, they had a document that they intended all along to use and did not provide it in initial disclosures or anywhere else during discovery. So now essentially they're being rewarded for hiding it, withholding it, and then saying like, oh, hey, we might use it for impeachment, but by the way, we didn't give it to you until the last minute, even though we fully intended to use it.
Well, can't you pull out anything for impeachment? Really, at any time?
Well, that's true, but I don't think a party should be rewarded for violating the civil rules regarding disclosure. I mean, I litigate in federal court, but
Yeah, I
mostly state
understand.
court. State court doesn't have, the broad parameters that federal court does. Federal court, I mean, I knew this anyway, but when I give discovery, I'm like, here's everything. Like, I don't, take it. I don't care. With very limited restrictions. But federal court is all about disclosure, and disclosure up front as soon as possible, even if somebody didn't ask for it, provide it. And they didn't. And so, but I agree with you. Yes, I mean, certainly I've certainly impeached people before with things that I had not disclosed, but it was because somebody lied on the stand in a way that I didn't anticipate. And then I went and got something that dealt with that issue. So.
Well, first of all, I take exception with the characterization that we hid something or that we're trying to take advantage of, the discovery rules or take advantage of any other, of the disclosure rules in the federal rules of civil procedure. This is not a document that was, willfully not disclosed or withheld. This is a document that's been in the debtor's possession for numerous years. And I believe our discovery responses and our initial disclosures are broad enough to encompass and that we would use anything.
All right. That's fine. I mean, you won this objection, so you're okay. Like I
Thank you.
said at the pretrial conference, neither of these deposition transcripts come in as admitted exhibits, but they can be used solely for impeachment. So with that, let's have your opening statement.
Thank
Thank
you
you,
for the
Your Honor.
clarification.
Thank you, Your Honor. I'm going to keep this very brief. we are here to establish at trial the sole and narrow element of the debtor's intent to willfully injure our client, plaintiff, Mr. William Nelson. Unlike the summary judgment proceedings prior, the burden of proof at trial is much different. We are not, the evidence is not going to be reviewed in the light most favorable to Mr. Wade, as in the prior summary judgment proceedings. We need only establish the willful element by a preponderance of the evidence, which means more probably true than not true. The evidence is going to demonstrate by a preponderance of the evidence that the natural consequences of the debtor's actions, i.e. repeatedly publishing false accusations of sexual assault, that he intended to cause injury to Mr. Nelson, or that the natural consequences of publishing a false allegation of sexual assault would lead to injury. We do not need to establish his affirmative intent. We are not going to get an admission in court from the debtor that he intended to injure our client in falsely alleging sexual assault. We only need to establish circumstantial evidence, which tends to establish that he must actually have known when publishing a false allegation of sexual assault that it would lead to injury. Now, we've heard multiple versions and excuses as to why the debtor does not have the requisite intent. We've heard, and I anticipate we will hear, that he was reckless, that he made a foolish mistake, and that is the first excuse. But if this was in fact a reckless one-off mistake, it would not have been a repeated systematic campaign of character assassination, over and over again publishing false allegations of sexual assault and other horrible things about our client. And any attempt to divorce the act from the intent is nearly impossible, given the allegations that we're talking about. I mean, these are not just innocent false accusations. I mean, these are the most horrific, heinous, vile accusations that one can level against another human, particularly in this day and age of social media, where the spread is so pervasive, and especially in a small community like Bainbridge Island. So this is not a situation where the debtor made a one-off mistake. This, again, was a systematic campaign of character assassination leveled at our client. And the evidence will establish that the debtor must have known the natural consequences of his action, that this would lead to injury. Again, we're not required to establish or get an admission in court that he intended to cause this injury. The law says that the circumstantial evidence surrounding the acts themselves can be self-evidencing. And that is what we will establish here today. Thank you, Your Honor.
All right, thank you. Ms. Lang, would you like?
We have one simple issue today to prove, and that is, did Mr. Wade intend to cause the injuries that Mr. Nelson sustained? And the simple answer is no. The evidence will show that his intent remained throughout the state and this court, that his intent was simply to warn, to protect, not to cause injury to Mr. Nelson. You cannot simply say, I have these injuries, it was because of what you said. They have to prove that my client had the actual intent to cause those specific injuries. And the evidence will show that he did not.
All right, now we'll take a witness.
Thank you, Your Honor. We'd like to call Mr. Nelson.
All right. Come right up here, Mr. Nelson, please. solemnly swear or affirm that the testimony you'll give today will be the truth and nothing but the truth? All right, thank you. Please have a seat.
And Your Honor, before we begin, a quick clarification in terms of how the court would like to proceed regarding exhibits. Would the court like us to be using copies that we have in our possession, or?
He'll have exhibit notebooks if they're not, are they there?
Okay. I
Do you have
wasn't
two
sure. so-
notebooks with you? Yeah, he's got his own set, so you just need to
Fantastic. That's what I
refer.
would want to ask. Okay. Thank you very much, Your Honor.
Yep. I'm ready when you are.
Thank you. Mr. Nelson, please state your name and spell your last name for the record.
William Peter Nelson, Nelson.
Thank you. And where do you live?
I live on Bainbridge Island,
Could you describe for the court that, Bainbridge Island?
small island, about 25,000 residents. I was born and raised there, fourth generation, for 64 years of my life.
Okay. And what do you do for a living?
I'm a building contractor, design, build, construction company that's been in business for 40 years on Bainbridge.
Bainbridge Island is the targeted consumer base?
It is.
How did you first learn about the post from Mr. Wade?
A friend of mine that follows Facebook brought it to my attention. It was shocking, disturbing, revolting, disparaging. I didn't understand where it was coming from or why.
And what did the post say about you?
Primarily, it started with a large sign of a development sign that I had in 2007. I think it was probably harvested from the local newspaper, showing me holding a sign, damning me with these allegations of rape, child abuse, malicious intent with other people. It was across the board embarrassing, detrimental, destructive.
Where was this posted?
It was posted on the Facebook page of Houston Wade's and on what he called the bad list of Bainbridge Island.
And these were both on Facebook?
Yes.
Okay. Were you able to find any other posts?
He posted on Twitter. He posted on the Bainbridge Islander, which is a local publication that's distributed throughout the community.
And what he was posting about you, how did they vary between the different locations, or did they vary?
The same message, just the same lies and distortions that he came up with from thin air.
Meaning the claims of sexual assault?
Sexual assault, child trafficking, raping women, abusing people in my life, abusing my children, my stepchildren, anything he could throw at me.
And when was the Bainbridge Island bad list article posted?
It was in October 2018 is when it came to my attention.
Okay. And were you friends with them on Facebook?
None. I don't do Facebook. I'm not a social media person.
So, how were you able to see all these posts?
Through my friends and contacts of people. I opened a Facebook page just to have access to Facebook, but I've never posted or put pictures up or done anything on Facebook.
So you didn't have to be a friend in order to see these posts?
No.
Okay. And how long did that post on the bad list remain up for?
At least till 2021, my recollection.
Do you remember when it was taken down?
I think it still was up after the Hauser judgment ruling of 2021
When you say Hauser, you're referring to the Superior Court Judge
in
Hauser?
Kitsap County.
And what did you do after you saw the post made by Mr. Wade?
Tried to evaluate, I mean, for me personally, I was disgusted. I was in shock. I became antisocial. I worked, went home, stayed out of the public because it was so public. It was so where I didn't understand where it was coming from or why or what the personal attack was about. And I had to stand back and wait and watch to see what it was that I don't understand. And over the course of time, nothing came from it. No facts, no truth, as we discovered over time.
You say discovered over time. Are you referring to the discovery process?
Yes,
So you filed a case.
I did.
When did you do that?
Soon after the post went up, we did go through a local Pena Regina Municipal Court to attempt at an injunction to cease and desist. We got a temporary injunction. That injunction was taken away when there was a pro tem judge that gave the temporary, and then the sitting judge removed it. And then we went into Superior Court and trial.
Mr. Nelson, can you, if you can turn and grab the trial binder of exhibits?
There's two. Do you want yours?
Yes, ours, please. Thank you, Your Honor, for that clarification.
The black one, I believe, yes.
If you can turn to number 5. Excuse me, yes, number 5, that was correct. And Mr. Nelson, the document in front of you, which has been entered as Exhibit 5 for the plaintiff, do you recognize what that is?
I do.
And what is it?
That was my initial attorney representing me in this matter, Kent R. Bratt.
And this is the complaint?
Yes.
Okay. And Mr. Nelson, can you pull the binder for the defendant, please? And go to their exhibit number 3, please.
Okay.
And do you recognize that document?
I do.
And what is that?
That's the initial post that I recall seeing in 2018 October with my, it's pretty obscured, but there's a picture of me holding up a sign from a development I started in 2005. And this picture was taken about 2007. And then associated is this defamation from Wade about being a rapist, cheats investors.
And by the way, do you recognize the picture in the upper left corner?
I do.
Do you know who that is?
That's Frank Rowe. He had a carpet company on Bainbridge Island.
And who is Frank Rowe?
He was a convicted child rapist that spent time in prison. I'm not sure if it was 20 years, but it was an extensive period of time.
And he was another member of the quote-unquote bad list?
Correct.
Now, you mentioned,
I missed the name again. Can you tell me what that?
Frank Rowe.
Frank Rowe. Thank you.
R-O-E.
now you mentioned, Mr. Nelson, that through discovery, ultimately you learned that there was no supporting evidence from Mr. Wade regarding the claims. Can you explain to the court what happened in discovery?
Throughout the trial and throughout the hearings and motions and discovery, Mr. Wade never brought anything factual. He claimed to have 60 witnesses, never brought more than 40 names, but then claimed that he couldn't get a hold of any of them, didn't have their phone numbers, couldn't reach them. Nobody apparently reached him. This was a very public display of defamation on my character throughout the 2 or 3, 4 years that this has been going on, but nobody stepped up but Mr. Wade.
Did he, was there any, what was Mr. Wade saying, well, let me backtrack. How did Mr. Wade's presence on social media change during the course of the case?
Not a great deal. He just found different nefarious ways to hide his messaging.
So, did he continue to make comments about you?
He did.
How so?
He carried on with the charge of that I was also involved with child trafficking, which he claimed also involved the Bainbridge Island Police Department. He continued to post even after the ruling by Judge Hauser, negative commentary and charges of rape, and I'm not going to pay that effing rapist a dime. He continued to make it very public about me.
Did he make any comments about the trial itself, or the case itself, during the course of the proceeding?
Are we talking about the
For example, through the discovery process?
discovery process? He just continued to try and drive home his false allegations through misleading statements about amount of witnesses, which never showed up. His claim that there was rape, child abuse, abuse of others, screwing over my investors. I mean, he ran a campaign of trying to destroy my character. It was a very personal attack.
And were Mr. Wade's attacks on you purely personal in nature?
Indeed, felt very personal and very pointed and very direct. He had a number of people on his list, but no one more important than me, and I don't understand why.
What do you mean by that?
Well, he had other members of this bad list, but none of them took the brunt of his attention and distortions more than I did.
Did he also attack your business?
He attempted to attack my business and dissuade people from working with me. He went to banking institutions, claimed to talk to banking.
Objection, Your Honor. These are facts not in evidence, and it actually has nothing to do with the Bainbridge Island Bad List post.
So what's the gist of the question? We already have from the state court judgment that he was harmed in his business and they awarded $500,000 in damages. So beyond that, where are you going with the question?
I want to just make sure that, again, laying a foundation that the attack against Mr. Nelson wasn't simply attacking him in a personal capacity, but also attacking him in his commercial/business capacity. So there was a double-pronged attack to harm him both socially and financially.
All right, I'll allow the question.
Thank you.
Your Honor, the business doesn't have a judgment on here.
Your Honor, the business and Mr. Nelson are one and the same.
Well, it's his business. Maybe there was an entity or something, but yeah, the objection's overruled. Go ahead.
So, Mr. Nelson, if you can turn to Exhibit D of the defendants again. D3.
Okay. Right.
Can you read for the court the second paragraph, which is just one sentence?
Starting with years ago?
No, right before that.
Okay. Bill Nelson rapes women. He also cheats investors, is an alcoholic and a cokehead, and also abuses not only to his partners and wives, but his children as well.
In the next sentence, please.
Stay away from Bill Nelson, and definitely don't give him any money.
Now, was Mr. Wade deposed in the underlying Superior Court case?
He was.
Were you present for that
I was.
deposition?
Yes.
This was an in-person deposition prior to COVID.
Correct.
And do you recall what transpired prior to going on the record?
Indeed.
What happened?
Mr. Wade entered the room. You, the court reporter, and myself were seated, prepared to have the deposition. And Mr. Wade wanted to bring attention to the record that he had discussed witness tampering with the Kitsap County prosecuting attorney in their office, to the extent that witness tampering was going on and that the prosecuting attorney was prepared to file charges against me for witness tampering. Mr. Wade stepped in the breach and said, but I've held her off. If you're willing to drop the case and pay me $50,000, I will hold her off from filing charges.
And was this discussed under oath during his deposition?
Yes, it was.
And what did he say during the deposition?
Basically,
Your Honor, objection. I think you've already ruled that anything that is said in the deposition is only used for impeachment purposes.
I did. I'll sustain. Doesn't mean you can't use it later when Mr. Wade's testifying, but not now under record.
Certainly. Mr. Nelson, Judge Epp, was a motion How did Judge Hauser of the Superior Court react to the discovery issues of Mr. Wade?
Objection, hearsay.
Your Honor, we're talking about a court ruling. This is not hearsay. Also, I think the court can take judicial notice of this as well.
Objection, Your Honor. So, first of all, the order is not before this court because the plaintiffs made a decision apparently not to put it into the record. And second, any comments made from the bench are not part of any findings unless they're incorporated into the order, as of course this court will know. So, we maintain it is still hearsay, whatever the judge said from the bench, unless it was incorporated into the order.
And we have the order, or we don't have the order?
It has not been put into evidence by the plaintiffs. That was their decision. So they're making...
Response to the objection?
Well, again, Your Honor, so first of all, we do think under Rule 201, the court can take judicial notice, but we can provide a copy of...
I can't take judicial notice of a statement by another judge that's not in the record because I have no idea what was said.
Except counsel is mischaracterizing what I was saying in terms of the court's statement of the references to the court's ruling, the court's judgment, the judge's written ruling regarding the motion for default/contempt.
Why don't you ask him a question about what the court ruled as opposed to hearsay about what the judge might have said, if that's how you want to go about it. But I won't allow him to testify as to what the judge may have said, unless there's some transcript or it's in an order or something.
I'm sorry, Your Honor. I understand that, of course, I'm not trying to be difficult, but essentially what then we have is his interpretation of what the order said. And that's still essentially hearsay. If they wanted that order into the record and thought it mattered, they should have moved it, they should have listed it as part of their evidence and asked for it to be included in the evidence. They didn't. And now they want him to testify as what his personal impression is or memory is of what's in an order. And that's just inappropriate. It's hearsay. It's a weird version of hearsay. But
I mean, I think it depends a little how far he goes. I agree if he's trying to interpret the order, I think you're correct. That's not appropriate, but it's just a factual question. If he's asking them in your litigation, how did they rule on the discovery motion? And he says, well, they granted it or they denied it or they issued sanctions. He can certainly testify to that from personal knowledge. So,
and Your Honor, I would agree with that.
To that extent, I'll let him answer.
Okay, thank you.
So, Mr. Nelson, a motion for default was issued in this, was filed in the underlying case, which referenced the discovery issues, including...
Objection, leading statement.
Yeah.
Leading question, excuse me.
Sustained.
What was the court's ruling on the plaintiff's motion for default?
The judge's ruling was based upon Mr. Wade not providing any evidence into the record to support his claims as to...
I'm going to object, Your Honor. He just said it was based upon...
Yeah,
facts.
sustained.
Mr. Nelson, do you remember specifically what was said in the ruling?
Objection, it has to be the order, counsel, not the ruling. I'm sorry, and I spoke the order, so I apologize, Your Honor. I shouldn't have said that.
All right.
I apologize.
Sustained.
Mr. Wade...
Let me help. Let's just start with the simple questions. If you know, how did the court rule on your motion for default? Let's start there.
Ruled in our favor.
You can go ahead.
Thank you. How did the court rule regarding the regarding the conduct of Mr. Wade during the deposition.
I'm going to object unless he can provide the exact wording that was included in the order on that subject. Otherwise, it's merely his impression or recollection.
Mary?
If you can't remember, then obviously state.
It was a short answer from the judge, basically that his behavior in the deposition.
Objection, Your Honor, he's testifying.
Sustained.
Mr. Nelson, would it be beneficial, would you be able to recollect your record? Would reviewing a copy of the ruling refresh your recollection?
Objection. Attempt to get into evidence documents which they didn't identify ahead of time, had a chance to do so, and didn't.
Your Honor, we're not entering the exhibit. We're asking to refresh his recollection.
What's the rule?
Because, I would just point out, essentially, if he's refreshing his recollection, what he's doing is reading the order. So that's reading the order into the record. When, again, an exhibit they didn't bother to include in the exhibit list.
I'm going to sustain the objection. I don't think it's proper.
Thank you, Your Honor.
Mr. Nelson, can you turn to Exhibit 1 of the plaintiffs? Do you recognize what that is?
Frank Rowe?
No,
P1
P1.
P1.
in the black notebook.
Oh, I'm sorry. I thought you meant the white binder. Okay.
And what is that?
William Nelson, plaintiff, Easton Wade, defendant.
This is the finding of facts and conclusion of law from the Superior Court.
Judgment summary.
And did Judge Hauser make a determination of what was the purpose of Mr. Wade's comments, published comments about you?
He did.
And what was that?
His intent was to destroy me.
Objection, Your Honor.
Can you read paragraph 3?
Yeah, I mean, sustaining to the, unless he can point to something in the document where it says that.
On page 3 of the judgment, paragraph 3.
Third page of T1 is, I think, where he's going.
The third page.
Is that correct? Third page?
Third page of the judgment.
Presumably the third paragraph.
And the third page?
Third page.
The third paragraph.
The allegations were all false. Defendant's purpose in doing these things was to run Mr. Nelson off the island.
Thank you. Does this order address Mr. Wade's future conduct?
His future conduct was limited in speech, defined by the words he had been using to defame me.
Are you referring to an injunction?
An injunction against the words that he used to defame me.
So he's prohibited.
Objection, Your Honor. Where is the plaintiff reading from in this order?
It's in the order.
What page are we on and what paragraph?
Mr. Nelson, can you turn to...
Hold on one second. I think the injunction is page 6, starting at line 10.
Thank you.
That is correct, Your Honor. Section 5 of that.
Paragraph 5, yeah. All right, go ahead if you have restate your question, maybe,
Thank
if you
you.
would, please.
So, Mr. Nelson, have you turned to page 6?
I have.
Okay. And can you go to line 10, which is section 5? Are you there?
I am.
Okay. And what is Mr. Houston currently enjoined from stating or inferring about you?
Mr. Nelson raped a woman in Fort Ward community. Mr. Nelson engaged in a cover-up with the Bainbridge Fire Department of said rape. A victim of Mr. Nelson, Elizabeth Cultrider, committed suicide as a result of his actions. Mr. Nelson engaged in illegal conduct at a speakeasy called the Chicken Coop, including paying money and liquor and drugs in exchange for illegal and immoral conduct, including rape and child abuse. That the illegal conduct at the Chicken Coop was done in conjunction with the Bainbridge Island Police and Fire Department. Mr. Nelson conspired with the Bainbridge Island Police Department to cover up the alleged crimes. Defendant accuses Nelson of such as running a child sex ring. Mr. Nelson committed domestic violence against his former spouse. Mr. Nelson has beaten the shit, excuse my language, out of his stepchildren and abuses children. Mr. Nelson is a cokehead. Mr. Nelson stalked Mr. Wade and tried to kill him several times.
In this judgment, did the court make a determination of, how did the court characterize these statements in the court's ruling? Let me rephrase the question, Your Honor. Please turn to page 2. You can turn to section 2, line 9.
In October of 2018,
Yes.
Mr. Wade began publishing defamatory statements about Mr. Nelson. These statements included allegations that he raped a woman in Fort Worth on Bainbridge Island, and he engaged in a cover-up with the Bainbridge Police Department. Allegations that a victim of his, Elizabeth Coltrider, committed suicide as a result of his actions 4 years after the election.
Objection, Your Honor. This document speaks for itself, and this doesn't go to the issue in this case, which is his intent. Mr. Wade's intent.
Yeah,
This is duplicative, too.
yeah, I don't think we need to have him, let me just comfort you that Exhibit P1 is admitted. I've read it a bunch of times, and I've already ruled that it's preclusive. So if that gives you any comfort, I don't think it's really necessary for Mr. Nelson to sort of reread the document to me in the record.
Thank you, Your Honor. And Mr. Nelson, since the injunction has been put in place, has Mr. Nelson's conduct towards you changed?
Mr. Wade.
Excuse me, Mr. Wade's conduct. My apologies.
Mr. Wade continues, even after the judgment, to post false statements about me.
Are any of those similar to what he's prohibited from posting?
Rapist.
Objection, Your Honor. We haven't received any evidence of this.
Your Honor, they're in the court record. If we wanted to look into the posts
Under their own court record, and you can cross-examine on these issues if you don't think your client's posted anything, or ask him if he has any documents that proves it, but I don't think there's any problem with the question as any post-injunction comments that may have violated the order seems like they would be relevant to Mr. Wade's intent. So I'll allow the question.
Thank you, Your Honor.
Objection's overruled.
Thank you, Your Honor. So, again, Mr. Nelson, has Mr. Wade continued to make posts similar to those that are described in, that he's precluded from posting?
Yes.
Such as what?
To the extent that he has made a statement that I'm not going to pay that lying sack of rapist anything on the judgment.
This was posted online?
Yes.
No further questions at this time, Your Honor.
All right, just give me one moment, please. All right, Ms. Lynn, I'm ready when you are.
I'm gonna.
Oh, I'm sorry, Ms. Lynn, I apologize.
You didn't know until I said something. All right. I'm just going to stand up because I'm short, so it's easier to see me.
That's fine, just make sure you're getting into the microphone.
Can everybody hear me?
It's coming through, Rebecca.
It's coming
Fine.
through, yeah.
Okay, yeah, you're fine, thank you.
Okay. All right. So I'm just going to be going through some of the testimony that you gave. I'm going to start with you first said that Mr. Wade came up with these claims of sexual assault out of thin air. Is that correct?
That's correct.
Okay. And you said you looked at the Facebook post after you were alerted to it, the one in the bad list?
Correct.
Okay. Did you look at comments that other people made on that thread?
There was very few comments really clarifying any support for Mr. Wade,
That's not what I asked
but
you.
I did,
I asked you if you read them.
of course, yes.
Okay. And but then based on what you just said, so you're asserting that there was only a few comments about people who supported him. Is that what I heard you say?
To my recollection, there was people that would cheer him on, but as far as any factual support, no, I didn't see anything.
So you didn't see, did you see anybody else making comments on that post or on the page, excuse me, I want to be precise, making other assertions against you for engaging in problematic activities?
No.
Okay. Sorry, just one moment, my co-counsel is, okay. All right, so I want you to turn to Exhibit D2.
That's the white notebook. Yeah.
You got to remind the court that the court has not yet admitted this into evidence, so I'm aware of that.
D2.
Yep.
Okay.
Okay. So that first page, does that look familiar to you?
On a Wade post, yes.
Right. And is that the post that you saw, one of the posts that you saw when you looked at the Facebook page?
I'm familiar with this post, yes.
Okay. And we looked at another one a few minutes ago, which was I think the first post on the bad list, which was in your exhibits. Do you recall that?
Yeah, the picture of myself.
Right, yes.
Yeah.
Okay. And then, so is it your recollection that this comment that we're looking at now from Mr. Wade is one that was below that first one we looked at? And
Was this one in the same sequence?
I'm
Is that what
sorry.
you're asking?
I'm sorry. I misunderstood. Sorry. When you went to the bad list Facebook page, did you see this comment? The one that we're looking at now?
I don't recall when I saw this,
Okay.
but it was early on, yes.
Let me just make sure I'm looking at the right
Yeah.
thing. Right. Are you on the first page of D2, the
Yes.
October 4 at 11:46 post? Okay.
Yes.
Yes,
Okay.
So you are familiar with it, correct?
I am familiar
Okay.
with it, yes.
Okay. And I was just a little confused because, again, I've had to jump into this in the last few days. So this post was, I'll represent to you, that this post was made on Mr. Wade's personal Facebook page.
Mm-hmm.
Is that a yes?
Yes,
Okay,
that's
sorry.
correct. Yeah,
Just for court purposes, we have to say yes or
Yes.
no. We can't do uh-huh or
we're correct,
That's
yes.
why I was asking
Thank
for
you.
clarification. Okay. But did you go to Mr. Wade's Facebook page and see this post after you were made aware of the bad list?
Yes, with fascination.
Okay. And then, so I want you to look through the next few pages, and see did you look at some of the other posts that were made in response to his post on his personal Facebook page?
Mm-hmm.
Is that a yes or no?
Yes.
Okay. And do you see the post made by Elena Brooke Simcoe Seisel? I don't no idea if I'm pronouncing that right.
Excuse me, Your Honor, I'm going to object to the extent that any of these comments are attempting to challenge the findings of fact in the final judgment, plaintiff's exhibit number 1.
Well, You are correct in what you just said, but I don't think that prohibits her from asking these types of questions. We are definitely not relitigating
Yes.
findings in the order, but she can ask these questions. She can ask these questions. I need to ask you one question about this exhibit, Ms. Yosman, just to make sure I understand it. I'm trying to get the chronology. Is the first page the earliest and all the following pages come
Yes.
later?
It is,
All right.
yes, sorry.
So I'm sorry, now I've
No.
distracted everyone, so would you please ask your question again?
So just to be clear, we're talking about comments made in response to Mr. Wade's post on October 4th, which is the first page of this exhibit. So I hope that makes the record clear.
It does,
Right.
thank you.
And so then I was asking about the comment by, I'm just going to say Elena Brooke. It's on page 3 of this exhibit. Did you see that one? Yeah. It's at the top of the 3rd page of exhibit D2.
It's highlighted.
Oh, right at the first page. Well, yes.
Okay.
Elena Brooke, Simcoe. He was horrendous. I remember him sniffing any young woman he could get close to.
I think she's just asking you if you saw it.
Yeah, that's all.
I thought maybe I should read it.
No, that's
Sorry.
fine. That's fine. But you still need to answer the question, because you could just be
Have I
reading
seen
for
it?
the first
Yes.
time.
I have seen this.
Okay.
But this has been some years ago. So
Sure,
keep
I
in mind.
understand. And do you know this person?
Have no idea who she is.
Okay. And then down at the bottom of this page, there's another comment from Shannon Evans. You don't need to read it. I'm just asking if you had seen it when you went to Mr. Wade's
I have, yes.
Facebook page.
Yes.
Okay. The next page, there is, I'm going to repeat from Ms. Evans, but there's a post from a Tracy Lang.
Yes,
And did you see that comment also when you
I
looked at it?
did.
Okay. By the way, we have to just make sure not to talk over each other. So even if you think you know what I'm going to ask, please let me finish my question so that before you answer, okay?
Yes.
Thank you. Because somebody at some point, a court reporter is going to have to maybe take this down. We don't want to make their life miserable, okay?
Thank you.
All right. Then I'm going to turn another page. It is, I think, it's 5. Okay. The numbers are so little that I'm struggling to see the numbers down at the bottom of the page. And then there's another comment from Shannon Evans. You saw that one as well, I'm sure?
Yes.
Okay. I'm going to turn the page. Let's see. It says 6. So then some other comments from Miss Evans. There's another comment from Ashley Cross DeGrow. You saw those?
Yes.
Okay. And then next page, there's a comment from a Samantha Goakey, Goakey. Did you see that one?
Yes.
Okay. Okay, next page is 8. There's continued comments from a Zakara Stratman. Did you see those?
Yes.
And you saw the comment from Doug Hunt.
Yes.
Okay. No, it's not. Then we're going to go through some pages. So let's turn to page 13 in the exhibit D2. There, if you look on the bottom of these pages, there's like a square that's not fully complete on the corners down below, and there's tiny little numbers underneath it down at the bottom of these pages.
You're on
It's the
D2?
second to last page, if
Yeah.
it helps.
I was trying to just help you
On
find it.
D2.
On D2, yeah, next to last page.
Yeah. And so, again, did you see more of the comments by Shannon Evans?
Yes.
Okay. And then the last page. Again, further comments by Shannon Evans and Ryan. There was also Mr. James. Did you see those comments as well?
I'm on the last page, but all I see is Houston Wade and Tracy Lang kind of cut off.
Huh. Okay. Well, maybe go to the next to last page, maybe, because you have a page, you described the page.
Shannon Evans, Keith Brodsky, Ron James.
Yeah, that's the last page.
Okay.
Okay, all right. Now, those some of the comments that you were referring to earlier when I asked you about looking at other comments?
I've seen these years ago, yes.
Okay. All right. And I think I asked you about a couple people specifically, but did you know any of the people who commented on here?
Shannon Evans, Tracy Lang, Ashley Cross DeGrosse,
Okay. Okay. All right. Is that it? I don't want to cut you off.
that's, yes.
Those
all
are the
that
people you know.
I would
correct?
know
Okay.
of
Okay.
in the community, yes.
All right. And did you ever take any action against any of the people who continued to make negative comments about you on this Facebook page?
No,
Did you communicate with them in any way? Tell them to stop saying these things about you?
I had no communication in relationship to this. Shannon Evans, I knew from a distance in the community I was developing at the time, but we never had any interaction. Hi, how are you at the coffee stand was the extent. Ashley Cross DeGrosse, she used to frequent this speakeasy backyard they called the Chicken Coop, which was a gathering place for neighbors and community members for socializing, had music, had a little non-charge backyard bar, outdoor fire pit. Many people gathered there. And Ashley was one, yes.
Okay. And then I think you said you knew Tracy Lang.
Tracy Lang is a co-tenant in the building, commercial building I'm in. She has a tattoo shop. I have a construction company office.
Okay. And wasn't there one other person you said you knew? Maybe I didn't write him down, so I.
Shannon Evans,
Tracy
Ashley
Lang.
Cross, and Tracy Lang.
That was it.
Yeah,
Okay, thank you. Sorry, I didn't get a chance to write those down. Thank you, Your Honor.
yeah.
Okay. And so you didn't file any lawsuits against them for saying these things about you on this Facebook page, correct?
No, I did not.
Why didn't you take action against any of them?
Every wolf needs a pack, and that's who these are. This is part of a pack of people that follow his Facebook page for legitimate reasons or illegitimate reasons. It's a social network for people like Mr. Wade. I'm not associated with.
So I understand that, but they nevertheless made some pretty harsh accusations
I
against
don't
you.
consider these to be harsh at all.
Somebody accusing you of,
Hearsay, I would say. Hearsay within the community, somebody to support somebody that's trying to make himself a social media giant. These are followers of Mr. Wade, not me.
I understand that, but you still haven't answered my question is why you didn't take action against them, because they made accusations. Let me finish, okay, because I can see you getting ready to answer. They made accusations against you, saying things like, he prefers them young, blonde, and uneducated, and other stronger comments. Don't let your daughter near him. I'm serious. He's super creepy and tried hitting on my son's girlfriend when they were in high school. Ashley DeGrow everyone knows to keep their daughters away. All those kinds of things are analogous to what Mr. Wade was saying, correct?
Aren't they protected under the First Amendment free speech?
I'm sorry, you don't get to ask me questions. You have to answer
the
mine.
question, please.
Thank you.
Okay. Rephrase your question or go ahead and ask me the question again.
Okay, so I asked you why you didn't sue them, given that they also said things against you that were analogous to what Mr. Wade said.
My main concern is Mr. Wade.
Again, you haven't answered my question.
I had no reason to sue those people. It's your say.
Okay. So why wasn't Mr. Wade's comments hearsay?
Because he went personally against me much more aggressively and charging me with rape, child abuse, child sex rings, child trafficking. I mean, egregious. Wouldn't you agree?
I'm not here to answer questions from you.
Okay.
But it's not egregious when somebody says you're super creepy and tried hitting on a high school girl, or that everyone knows to keep their daughters away from you.
Wasn't going to open 5 lawsuits, ma'am.
Okay.
Take down the king rat, you can take down the rest.
Okay. Now, but I'm going to go back to kind of where I started with this, which is you asserted that Mr. Wade came up with his allegations against you out of thin air, right?
Correct.
Okay. So don't you think the fact that other people have similar beliefs about you that they posted on his website indicate that Mr. Wade did not make them up out of thin air?
Objection, Your Honor. Relevance. These allegations have already been determined as a matter of law to be false, and now we're getting into relitigating the underlying judgment and its findings of fact.
I'll overrule it. I don't think we're not relitigating the other judgment. She's trying to indicate that if a bunch of people thought this thing, maybe Mr. Wade believed they were true, and that might go to his intent on why he posted this stuff. So I think objection's overruled. You can ask these questions.
Thank you, Your Honor. That is exactly why I'm asking the questions. Okay. All right. Now, you testified.
Just so everyone's clear, I mean, and we've talked about this before, the statements are false for the purpose of this trial.
Yes. Oh,
because that's what the state court found.
Yes.
But when he made the statements, whether he knew they were false or believed them to be false can be relevant to his intent, and that's why I'm allowing the line of questions.
And I will be clear again, I'm not trying to relitigate the state court's ruling. I understand completely, Your Honor. So you said that the bad list was taken down in 2021. Is that correct?
Correct.
Okay. And how do you know that?
Didn't see the post after the ruling.
Okay. But did you look before the ruling came down to see when it had been taken down?
Yes.
Okay. So you looked at it in 2020?
Correct.
And you looked at it in 2019?
Yes.
Okay. And what was happening on it in 2019?
Primarily Mr. Wade's post. His activity of these commentary activity came after his initial post. And if you look at the dates and times of the follow-up posts of others, they fell off fairly quickly as Mr. Wade continued to march on, posting about me.
So I want to be clear. You're contending that after you sued Mr. Wade, and there was a hearing on the temporary restraining order, et cetera, and the case was progressing, that Mr. Wade continued to post things on his personal Facebook page and on the bad list, continuing to make these accusations against you.
Yes.
Okay. And do you have evidence of that?
We have a whole book of evidence.
In this case, or not in the state court case?
In the state court and also in this case as well.
All right. I just want to check something here.
And Ms. Huesman, the time frame of your question was while the state court lawsuit was pending, but prior to judgment?
Yes, correct. I said I asked him about 2020, 2019. I was just looking to make sure I had the state court judgment correct. It was entered on September 27th, 2021. I will also just make note on this subject that in the findings of fact, there was no findings about continued posts. It's only posts in October 2018 that are the subject of the factual findings in the order. Okay. All right. Okay. Now, I want to confirm
Ms.
that...
Huesman, let me just
Sure.
just since you made that statement, let me just say, unless you want to point me to something in that judgment, I find it not as clear as you stated, because paragraph 2 of the findings say in October 2018, Mr. Wade began.
Okay, I see your Honor's
It doesn't
point.
preclude that.
Yeah.
I don't have any evidence right now yet that
Right.
you posted after that, but I wouldn't say the judgment necessarily precludes that.
Sure. Okay, that's fair. Thank you, Your Honor. Not that I need to approve you.
Well, I just think it's important for
No,
everyone to understand. I don't want to surprise anybody
No.
with anything unnecessarily.
Precision is necessary for everybody. Okay. Now, when we looked at previously the order entered by the court, your counsel was pointing out that the court found that Mr. Wade's purpose was to run Mr. Nelson off the island. Do you recall seeing that?
Yes,
Okay. Do you still live on Bainbridge?
I do.
Okay. And you still operate your business there?
I do.
And I understand, correct me if I'm wrong, that your business did have to file bankruptcy in
2013.
2000. Thank you. Okay. And you came out of that bankruptcy and are continuing to operate that business?
It was a struggle. Yes, I am.
Sure. But I'm sure that was probably a big result of the 2008 financial crisis, right?
Correct.
Okay. Now, you also testified that Mr. Wade has continued to make posts against you, violating the language of the court order. So since September 27, 2021. Is that accurate?
That's correct.
Okay. And when did you see these posts?
This is now September
2023.
2023. Thank you. In the spring of 2023,
And where did you see this post?
Facebook,
And whose Facebook page?
Mr. Wade's.
His personal Facebook page?
Correct.
Okay. And is that the one you said, you quoted him as saying, I'm not going to pay that lying sack of blank, that rapist?
Any money, correct. Yeah.
Right, okay. Okay, and he put that on his personal Facebook page, correct?
Yes.
Okay. And have you taken action in the state court to get relief because of the violation of the restraining order?
Been focused on this matter, but no, I have not.
Okay. And do you have a copy of it? The post?
With me. Unless, Alex, do you have,
Oh, hang on.
I don't have anything in front of me.
It's okay.
so-
It's just you can't ask questions of
Okay,
me
all right.
or your counsel. It's okay. Did you make a copy of it when you saw it?
It would be in the record, and this has been a long-running event, so I'd have to go look in the record, ma'am.
Well, what I'm asking you is, did you make a copy, did you print a copy of his post when you saw it?
We keep electronic file on everything Mr. Wade says and does.
Okay, and who's we?
It's in my office. It's within my record keeping that I keep track of what's old, what's new with Mr. Wade.
Okay, so now is that you personally or staff?
Staff.
Okay, and who in your office is responsible for keeping track of what Mr. Wade does?
I use primarily Timmery Jenkins, who has been very helpful in managing the whole Facebook matter with Mr. Wade's postings.
Can you spell that first name?
Timmery, T-E-M-R-E, Timmery
Okay,
Jenkins.
yeah, thank you. It's an unusual name, so
Yeah.
make sure we have it right. Anybody else?
Deb Prouty is
And
my
that's-
office manager,
Sorry. Can you spell the last name, please?
Prouty.
Okay. Anybody else?
No,
Okay. So.
I'm sorry, I missed the second name. Would you give me the second name again?
Deborah Prouty, Prouty.
All right, thank you.
All right. And so those are the two persons in your employ who are specifically tasked with keeping track of Mr. Wade's social media. Is that correct?
They manage the business, so it's not the only thing they do.
Yes, I'm sure. Yeah, well, one would hope there was not a full-time job. And
No.
Yes.
Well, it was at one
Yeah.
time.
But they are the ones who are tasked with keeping track of what Mr. Wade.
Yes, yeah.
You need to let me finish. What Mr. Wade says on social media, correct?
Yes.
Okay. And what are they supposed to do when they see him posting about you?
Keep record of it.
Okay. So if Mr. Wade did post what you testified to a little while ago, somebody in your office should have kept a record of it, correct?
Correct.
Okay. And then what do they do with it when they're keeping it?
We keep it in an electronic file.
Okay. And do you turn it over to your attorneys?
I've turned everything over to my attorneys.
Okay. So if there was a copy of this post that you said occurred in spring of 2023 on Mr. Wade's Facebook page, then there would be electronic evidence of that, which obviously could be printed, but there would be electronic evidence of that you would have turned over to your attorneys. Is that correct?
Correct.
Okay.
To my knowledge, yes.
Okay. Do you check in with these ladies about whether or not Mr. Wade's posting anything, get an update?
We don't go online every day, no. But on occasion, we'll do a sweep of anything, Twitter, Facebook, any other outlets that we've known Mr. Wade to use in the past and see what's up.
Okay. But what I was asking is if they find something, they would tell you, correct?
Yes.
Right. And then is it you or them who would give it to your lawyers?
I would authorize it.
Okay. But they
Yeah.
would do it for you?
Yeah.
Okay. All right. And that's been consistent since basically kind of this whole can of worms opened up in October 2018?
Correct.
Is that correct? Okay. Is there anybody else who would have access to those materials?
Not to my knowledge.
Okay. All right, let me just double check my notes for a minute. Oh, okay. I'm sorry. 1 second. Sorry. How did Louisiana Orchard? Okay. And who is Richard Lee Rainierson?
He is a member of the community. I've never met in person. Apparently, he's on Mr. Wade's watch list.
Okay, and have you
Ms.
communicated?
Hisman, can you spell or give me that last name again?
That's a big one.
I will spell it for you.
Okay, that'd be great.
That's why I had to ask. Mr. It's okay, I got it.
My handwriting.
R-E-Y?
No, R-Y.
R-Y, excuse me. R-Y
Yep.
Nearson.
All right, thank you.
Thank you. And so, you have never met him in person, but you have communicated with him.
I've had several communications with him via, email.
Okay, email.
Yeah.
And, I'm sorry, and you said that he was on the bad list?
Don't know if he's on the bad list, but I know he's not a friend of Mr. Wade's, nor is Mr. Wade a friend of his.
Okay. And then has Mr. Rainierson been someone who's given you information about various posts by Mr. Wade, screenshots, records of his posts, et cetera?
Not to my knowledge, just commentary,
I'm sorry, what do you mean by commentary?
just good luck, keep up the good fight.
Okay. But he hasn't sent you any information about Mr. Wade's posts?
Not to my knowledge, no.
Well, that kind of puzzles me because how would you not know if he sent you something?
My primary source of information is internal.
Okay. Well, I know, but I'm just curious as to how, if Mr. Rainierson sent you something, how would you not know?
It's been 5 years in this process. I don't recall Mr. Rainierson sending me anything other than support.
Okay. And he didn't send you any videos that he had taken of Mr. Wade?
No,
No other photographs that he took of Mr. Wade?
not to my no.
Okay. And if you had any of that, that would be retained at your business location as well?
Yes.
Okay. Just one second, I'm going to talk to my co-counsel. I'm sorry, I did forget to ask you about one thing earlier. Did you have a police report made against you by one of your ex-wives or girlfriends? Ex-wife, I guess.
19, would it be, do you have a date, time? I mean, there should be,
1994?
that was my ex-wife,
Ex-wife?
yes.
Okay. And I'm sorry, it wasn't actually, was it, she went and got a, excuse me.
In 1994, is that what you said?
Correct.
Yes. She got a temporary violence restraining order, right?
Don't believe it was ever any violence. It was just, she didn't want me coming to the property.
Well, that's what they're called. They're
Well,
domestic violence.
Might be
Temporary.
a misnomer to call it violence because there was no violence.
Okay. So actually you can look at Defense Exhibit 10. It's in the book. Yeah. Again, has not been admitted, Your Honor. So. Okay. Okay. This is 11. Okay, you didn't have one on it. Okay. So, have you ever seen this document before?
Oh, yes.
Okay.
It's-
And so, Mrs. Nelson at the time did mark the box saying that she alleged infliction of fear of imminent physical harm, bodily injury, or assault between family or household members. Do you see that?
Which line item are you?
It's the
On the
Big-
very left.
big B,
And then in the
and then
middle.
subsection D. I'm sorry, I should have
B,
pointed that out to
And it
you.
would be infliction of fear or imminent physical harm, bodily injury, or assault between family or household members. I do see that box checked, yes.
Okay. And then, I'm going to have you turn to Defense Exhibit 11. So have you ever seen this document before?
'94. I recognize the document.
Oh, so you have seen it before?
Yeah, it's been some time ago, yes.
Okay. Well, sure, yeah, that's quite a while. So if you go down to where the handwriting starts, you see that?
The handwriting, yes, I've been reading it.
Okay, go ahead.
So her claim, yes, I've read this.
Okay,
False claim, but yes, I read it.
okay. Well, that's fine. You're asserting that it's false. But do you know if this is in the public record?
Well, it's here on this public document, correct?
So it is in the public record. You know
Yeah.
that, right?
Mm-hmm.
Yes or no?
Yes.
You know that because it was in the public record that anyone can get access to this document and take a look at it, right?
Yes.
Okay. So I understand that you maintain it as false, but do you understand why a third party looking at these documents that your ex-wife filed might find some support for accusations that you've engaged in, let's say, bad acts as regards your family?
False and misleading statement, 1994. You can make and take of it what you wish in a divorce proceeding.
Okay, well, that didn't answer my question. And I understand you maintain it's false, and
Yes,
it's not my job, and I'm not here to question
sure.
who is telling the truth. Either one of you. I don't know. No. Well, you might, but the rest of us don't. My question really is just about that. Do you acknowledge that some third party who doesn't know either you or your ex-wife reading this could take from it that at the very least there is a potential possibility that you were engaged in violent behavior with your family?
Assumed? Yes.
That's not what I asked. I said that they can take from it that there's at least a basis for that. Don't look at your counsel. They don't get to direct you. Look at me.
When it's a false and misleading statement,
Again, Mr.
you
Nelson,
can make of it what you wish.
that is your,
Yes.
please answer my question. Whether or not it is a false or misleading statement in your opinion
Somebody, yes.
is not relevant.
Wait. Stop talking over each other. Go ahead, Ms. Hilsman.
Thank you. Your assertion or belief that it is false is not relevant to the question I asked. What I asked is, again, a third party who doesn't know you or your ex-wife, whether or not they can look at it and reach a reasonable conclusion that there may be some veracity to accusations that you have engaged in violent behavior towards your family. That's all. Not whether it's true.
They could believe it, yes.
Okay. Thank you. All I wanted to ask. All right. Did you? Oh, yes, sorry. So where's that? Sorry. Okay. Oh, sorry. I was all of a sudden right in front of the microphone. Can you quickly turn to page 5, Defendant's Exhibit 5? Huh? Oh. Too bad that Dan took the minute. Ready?
I'm on page 1, work to
All right.
resume on Bainbridge Development. Is that the page?
Right. So I'm assuming you've seen this article and read it.
Years ago.
Yeah. Okay. So, I realize you didn't contribute to this and it was, done by a reporter, but, is the timeline and the general description here made of what happened with this development, et cetera, accurate?
No.
No? Okay. And what is inaccurate?
First paragraph, 2006, developer Nelson.
Okay, you're on page 2 now.
Yes.
Okay.
Performs a $1 million remodel of the crumbling manor house. I mean, did start that, but the dollar figure's incorrect.
Okay.
2006, his acreage is off by 2 acres. Giant project is halted as recession hits. Project's bank, City Bank of Linwood fails, and Nelson no longer can draw on loans. Almost 1 million liens are filed by subcontractors. There was actually 500 million, or 500,000, about a million, just for the sake of accuracy. The aborted development reverts back to the bank, now Whidbey Island Bank, which assumed the assets of Linwood Bank.
Okay, so the only thing you've identified clearly to me as being wrong at this point is some of the acreage and I think a date on something, and then
Yeah,
the lien.
accuracy.
I know, I get that. That's what I asked you for. And you said it wasn't $1 million in liens; it was 500,000. Those are the items that are inaccurate, right?
Correct.
Okay, but overall, other than those items, this article is an accurate timeline of what happened with this development, and then how the development played out and how.
By and large, yes.
Yeah. Okay. All right. Thank you. I think that's it for now. Sorry, I know you wanted to break for lunch around noonish, but can we at least take a 10-minute bathroom break?
You may, so we'll be recessed till 11:25.
Thank you.
All right.
All right, for the beginning session.
You may be seated, thank you.
Your Honor, I had realized that I forgot to ask Mr. Nelson just a couple of questions, so it really will be just like a couple of questions.
That's fine, Mr. Nelson, if you'd return to the stand, please. And I'll just remind you, you're still under oath.
Thank you. Sorry about that. That's what I forget. Sometimes I forget to check on my notes. So I just have a couple questions.
I need
for you.
just 1 minute.
Oh, I'm sorry.
Ms. Chisholm. All right, go ahead.
Thank you. Have you ever been charged with driving under the influence?
Yes.
How many times?
Twice.
Only 2 times?
I had negligent driving prior to a charge of driving under the influence in 2012 or 13, and then 2018.
So I'm just going to, thank you for that. I'm just going to remind you that what I asked you about, I thought, and maybe I said it wrong, is, okay, let's start with, have you been arrested for driving under the influence?
Yes,
Okay, how many times have you been arrested for driving under the influence?
twice.
Only twice.
But
you, okay, I want,
when you say the influence, I had 2 previous infractions, so over a course of 20 years, there's been 4 arrests.
Okay. And then 2 of them were infractions, resulted in infraction charges? Is that correct?
Negligent driving, yes,
Okay. And those were reduced charges?
correct.
Okay. And then the 2 others, what were the charges in those?
2012 was a deferred prosecution, and I went through a program for 5 years.
Okay. Did you complete it?
I completed up to the last 6 months of my deferred prosecution and then reoffended in 2018.
Okay. And then what happened in 2018 with those charges?
I was at the ferry dock, Coleman Dock, coming home, and we had 2 cars, my car and another car came, touched, stopped, got out of the car, attempted to discuss the matter with the other driver. The other driver was not responding, so I drove on the ferry.
Okay.
I was asked to come back off the ferry, and they gave me a sobriety test, and I blew a .15
Okay.
and was arrested.
Okay. And I believe you were ultimately charged with hit and run and driving under the influence?
The hit and run charge was dropped.
I know, but I asked you if that's what you were charged with. So let's just stay focused on what I'm asking, okay?
Okay,
All right. So that's what you were charged with. And then you just pled to the DUI charge, correct?
trying to recall how we pled, but that probably could be accurate as far as the DWI charge, yes.
Okay. Thank you. And I just, on the other times you were charged, were those for being over the limit on alcohol?
No, on the first 2, no.
What were those related to?
Don't know that there was ever a determination. It's been 20 years, ma'am, I don't recall.
No, I understand, but what were you accused of being under the influence of?
I don't recall.
Okay, so have you ever used illegal drugs in your lifetime?
I have.
Okay. And so could you have been under the influence of illegal drugs in those 2 infractions?
Speculation,
Yes or no, please?
no.
Okay, so you did use illegal drugs, but you know that you were not under the influence of those when you had the 2 earlier charges?
So why the charges are dropped or reduced to negligent driving,
Yes, I understand what the charges were dropped.
which is erratic driving.
Again, that's fine. That's not what I'm asking you. I'm asking you if you're certain that you were not under the influence of illegal substances with those previous 2 incidents, no matter what they were pled down to.
Correct.
Okay, so you used illegal substances and you never drove while under their influence.
No.
Okay? So you never drove under their influence.
Of alcohol, I did.
Oh, okay. And by the way, what illegal substances did you use?
In the past,
I guess.
marijuana.
Okay. Anything else?
I had tried cocaine years ago.
Okay. Anything else?
No.
Okay. So if I understand you correctly, we've had 4 DUI incidents. Various, understand they were pled down to different things, but there's been 4 incidents, correct?
Correct.
Okay. And so the current, or the one from 2018, what happened as a result of that?
Went back into a 5-year, what would you call it? Probationary period?
Okay.
Yeah.
And is that complete yet?
2023, what is this, 18, 19, 20? Yes, it is.
Okay.
We're still working on getting the legal part of it done with DOL, but yes, it's completed.
Okay. By DOL, you meant Department of License.
Yes.
Did you have your license restricted?
During that 5-year period, yes.
And so you couldn't drive at all?
No, I could drive.
Oh, you just had restrictions?
Yes.
Okay. Have you ever been charged with assault?
Not to my recall, no. I don't, I mean,
Sorry, I just was.
no, I have not.
Yeah.
Okay?
I might have some arrests, but.
Yeah, but I'm 64 years old. Give me a break.
Okay, well, most people would remember, but.
Yeah,
Okay.
no, I don't hit people or assault people, so no.
Okay. I think that is, I think that answers the questions that I had. Okay. Thank you very much.
Hold on one second. Your counsel may have more questions.
Your Honor, no, I have no further
No,
questions.
all right, thank you. All right, call another witness.
Yes, Your Honor, I would like to call Mr. Wade.
All right, Mr. Wade, if you'd come up here, please. Raise your right hand, please. Do you solemnly swear or affirm that the testimony you'll give today will be the truth and nothing but the truth?
Yes.
All right, thank you. Please have a seat. What do you need?
I need a cell phone.
Is it somebody's, does somebody have a cell phone close to the mic? We're getting feedback. If you could push it away from the mic. Thank you.
Sorry about that.
And I'm ready when you are.
Mr. Wade, please state your name and spell your last name for the record.
My name is Houston Wade, last name Wade.
You use social media regularly, correct?
I do.
You use Facebook,
Yes.
Twitter?
No longer.
You did it previously?
Yes.
You did
Hold on
prior.
one second. We're still having a phone issue somewhere.
Is your cell phone, I mean, your laptop?
That mic's on too, Ms. Heelsman, so can you put it on the chair maybe or something? It's just creating feedback, so
Oh,
our
sure,
record's
sorry,
getting
sorry.
distorted. All right, go ahead.
And so you said you no longer use Twitter, but you previously did?
Yes.
You used it during the course of the trial of Mr. Nelson?
I had it, yes.
You used it after the trial as well?
Yes.
You used it before the trial?
Yes.
You also have a YouTube page?
I do.
You do live streams on YouTube?
I do.
Do you like to engage with your audience?
I do.
Take questions?
I do.
You enjoy the interaction?
I do.
You are the creator of the Bainbridge Bad List?
The Bainbridge Island Bad List.
You are the creator of that?
Yes.
You left the commenting function on that on, correct?
I did.
And you responded to the posts?
Some. Yes.
You responded to questions as well?
I believe so, yes.
You also posted on the Real Bainbridge Islander Facebook page?
May have commented on there.
But that's a post, that's correct?
In response to it, so yes.
And that's, the public can see it?
Members of the Real Bainbridge Islanders could, yes.
And the members are presumably members of the Bainbridge Island community?
Yes.
And in these posts, you allege that Mr. Nelson committed domestic violence against his former spouse?
Those aren't my allegations. Those are his former spouse's allegations.
You posted that,
Yes.
correct? And you didn't cite the document at the time, did you?
So, I'm sorry, you went a little fast for me. What post
And
are
you
we
didn't
talking about?
cite,
No, go back like two for me, would you? When you first asked it, what was the topic you were asking about?
you told people online that Mr. Nelson committed domestic violence against his former spouse.
Domestic violence, okay.
I did.
You told people online that he abused his stepchildren.
I did.
You told people online that Mr. Nelson tried to kill you several times.
No, he threatened to kill me.
Objection, Your Honor. I'm objecting to this whole line of questioning. We've already established what he has said online, and we're only trying to get to his intent at this hearing. I don't need to rehash what was said.
Your Honor, we're here obviously about his intent at the time, and all of his comments go towards that.
Yeah, I'll overrule the objection.
You told people online that Mr. Nelson conspired with the Bainbridge Island Police Department to cover up crimes including the running of a child sex ring?
Those were allegations made by Megan Angel and Ryan Landworth.
Objection, non-responsive. Did you post this?
Oh, I posted it, yes.
You told People Online that Mr. Nelson was being investigated by the FBI for engaging with illegal conduct, including for rape and child abuse.
He was, yes.
In fact, you referred to my client multiple times as a rapist online, correct?
I did, yes.
You referred to him as a rapist during the course of the trial, correct? During the course of the case.
Talking about the state court case?
State court case, yes.
I did at least once, yes.
Okay. And you referred to him as a rapist also after the court had issued its final ruling, correct?
That can be subjective because I did not get the final ruling for months after it was made because my due process was violated. And I had no idea that there had been the case ongoing at that point.
Mr. Wade?
Yes.
Do you recall receiving, let me first ask you, please turn to proposed exhibit number 2 of the plaintiffs.
Your Honor, this has not been admitted. I'm objecting to the use of this exhibit. All of the posts to this exhibit cannot be properly authenticated. I objected to this responses as well for all of the posts, which our responses to the plaintiff's second set of requests for admissions is actually P3. All my objections are noted in that exhibit.
Well, look, I looked at both P2 and P3 after the pretrial conference, and I don't think it works to exclude in both because some of the things he did in fact admit, and the other ones he did not and did not acknowledge them as his. So I think we're really going to have to, depending on what the questioning is, we're going to maybe have to deal with it as parts of the exhibit. So I got to see where the questioning goes, but
Sure.
I would overrule the exclusion of these in bulk. I think I misspoke. I think it's 2 and 3, not 3 and 4. Yep, it's P2 and 3. So let's see where this goes. Go ahead.
Mr. Wade, can you turn to exhibit F it's basically a subpart of exhibit F of plaintiff's exhibit 2.
Page 36, I can see the bottom corners.
Objecting to this exhibit, Your Honor. We have no idea where this exhibit came from. There's no identifying markers on this exhibit. We have no idea if it...
Well, we'll find out when he asks the question. You can ask a question.
Mr. Wade, do you recognize the document in front of you?
I do.
Do you recognize the post from Rock God at the W. Houston?
Yes.
And is that your Twitter? Was that your Twitter handle?
Yes, that was.
And do you recall posting this, or tweeting, if you will, this comment?
Yeah, looks familiar.
And what did you state?
I said, I'm not paying a rapist shit.
And this is in reference to Mr. Nelson, correct?
Yeah, probably.
And you were responding to a post from an individual with the handle Jack B. Wright, correct?
Yes.
And what does Jack B. Wright state in his or her tweet?
He says, you paid off the $500,000 you owe for the guy for defamation.
So he's referring to the judgment.
Apparently at this time, yes. But I didn't know there was a judgment at that time.
Hold on, we all got crossed. Would you ask that question again?
So my question was, he's referring to the judgment against you in this case?
Looking back, that appears to be what he was referring to, yes.
Okay. And it appears at that time you knew that because you referred to Mr. Nelson in your response.
Well, he was the only one suing me for defamation.
And when was this tweet made?
It says here January 30th, 2022.
And when was the court's ruling, specifically the finding of facts, conclusions of law, and judgment and permanent injunction?
I believe that was in September of 2021.
So months prior then.
Yes.
And that was for, the judgment was for $500,000, correct?
That's what I found out later, yes.
And did you say how many times you referred to my client as a rapist during the trial?
Objection. Can we get clarification on what do you mean, how many times?
Do you know how many times you referred to my client online as a rapist?
Oh, no, I don't. I know at least once after I won the injunction hearing in 2019. But the other times, I didn't use his name in a post.
The Bainbridge Island bad list target audience was Bainbridge Island, correct?
Yes.
As was the Bainbridge Islanders Facebook group.
That is also a community page, yes.
You've also made posts via your personal Facebook account about Mr. Nelson, correct?
I have, yes.
And in fact, the first post that you made about Mr. Nelson was prior to the bad list creation, correct?
It was. I didn't originally use his name.
What was that?
I did not originally use his name, though.
But did you reveal it in the comments?
I did after I was asked.
Now, it's fair to say that you don't like Mr. Nelson.
I hate the man's guts.
You don't want him to be successful, correct?
I don't care if he's successful. I just don't want him to hurt people anymore.
You don't want his business to do well.
I don't care if his business does well. I just don't want him to hurt people anymore.
So when you tell people not to give him money, that's not in relation to his business?
He ran for office twice. People gave him money then.
Was he running for office in 2019?
He was not, but that doesn't preclude him from running again.
Now, you've stated that you tried to bankrupt him, correct?
I did make that statement, yes.
And you posted online that you worked very hard to bankrupt Mr. Nelson, and you finally did?
I did post that, yes.
And you've stated that you don't want people to do business with him because he hurts women and children?
Objection. That's it's not stating what was in the post correctly.
Yeah, it's not exactly how I worded it.
All right, I lost that a little. I'm going to sustain the objection, but just so you can answer the question again and I can get the answer, please.
So the question was, you didn't want individuals to do business with Mr. Nelson because you claim he hurts women and children, correct?
That's not how I worded it, no.
Is that not what you thought, though?
Not exactly how my thinking worked, no.
Can you turn to plaintiff's exhibit number 12? Can you turn to page 47? And I'd like to direct your attention to line 17.
Line 17, okay?
And you were asked, although you weren't directly involved in the recession or anything, it was your understanding that you played a part in his bankruptcy, correct?
I see that, yes.
Yes. And your response was, if there was a part to play, it was because my friend Catherine Wayno at the time was a commercial loan officer, and she was telling me about any development that was going to be going in at the Linwood Center. Someone had come in and asked for a loan, and I asked her who it was, and she said it was Bill Nelson. And I told her about the rape and abuse that Mr. Nelson had done against people in my life and classmates of hers and mine, and she rejected the loan.
I did say that, yes.
And this wasn't the only loan that request that was rejected by her, that was made by Mr. Nelson, correct?
As far as I know, yes.
Sorry. I was trying to open something, sorry.
Go ahead.
Now, it's fair to say that you don't want the public to think well of Mr. Nelson.
The public already does not think well of Mr. Nelson, regardless.
Objection, non-responsive, Your Honor. Strike.
Yeah, I'll strike.
You don't want the public to think well of Mr. Nelson, do you?
No, I don't.
You don't want him to have a date, for example.
I don't think men who hurt women and children should go on
Objection,
dates.
non-responsive. Move to strike.
Sustain.
So again, you don't want him to even have a date.
No,
You want him to be a pariah, correct?
he is one.
Objection, non-responsive. Move to strike.
Sustain.
You don't want him to be you want him to be a pariah on the community, correct?
I'll say again, he already is one. It's nothing but my want on that.
Objection, move to strike, non-responsive. Yes or no?
I don't want anyone to be a pariah. Whether they are or not is not up to what I want. I want people to be good people.
So is your answer no, you don't want him to be a
No,
pariah?
I don't want anyone to be a pariah.
So you did say, though, that Mr. Nelson deserves to be alone and not in contact with anybody, correct?
Yes, because he hurts people.
So isn't that making him a pariah?
That is him being a pariah. I didn't make him that way.
Now, the Superior Court concluded the purpose for your defamation was to drive Mr. Nelson from the island, correct?
I don't have that in front of me.
If you can turn to exhibit number 1. Turn to page 3, please.
There's 3.
Between line 3 and 4,
Line 3 and 4, yes.
paragraph 3.
Paragraph 3.
it states the allegations were all false. The defendant's purpose in doing these things was to run Mr. Nelson off the island.
That's what it says, yes.
So being run off the island and being a pariah in one's community is ultimately what you hope to achieve, though, correct?
No, because I was never at this hearing. I never got to defend myself.
Objection,
Well,
move to strike non-responsive.
it's not that I'm being non-responsive, I'm putting context to this. Nelson's attorneys wrote this, and the judge signed it without my ever having the ability to defend myself. So if the judge rubber stamps an order that Nelson's attorneys wrote,
And objection, non-responsive.
I'll sustain, but, I mean, it doesn't matter. We're getting into this preclusion stuff again. The judgment is what it is.
No, I just have a limited amount of time, and I'm trying to just
Yeah, I
move things
understand.
along. I apologize, Your Honor.
No. You have time. Go ahead.
It's fair to say that being a pariah in one's community is harmful, correct?
I'd say being a pariah is harmful to the community.
So it's not harmful to the individual.
The individual being a pariah is the circumstance of their own making.
You believe Mr. Nelson should be punished?
I believe he should be charged on multiple counts, yes.
He deserves to be punished?
Yes.
You believe in karma?
I would think that,
Yes or no question.
I'm not a particularly religious person, nor am I spiritual. I would think the idea of karma is comforting, but often not realized.
You stated you believe when people do horrible things to others, that the universe eventually results in them getting what they deserve.
I think I said that at one point, yes.
And when you were asked about this, about karma, you thought that this was a universe giving Mr. Nelson what he supposedly deserved?
No, it was more me making more people in the community aware of what he had done.
Did you not think that karma, question withdrawn, Your Honor. If you can turn to Exhibit 12, please.
Sorry, what exhibit did you say?
Exhibit 12. Page 41, please.
I missed it.
41, please. On line 7,
Yeah.
you were asked your statement in which you said that it was karma that Mr. Nelson suffered from bankruptcy that directly relates to a financial harm, correct?
That's,
That's the question that was posed to you?
it says, yes, your statement in which you said that it was karma that Mr. Nelson suffered from bankruptcy that directly relates to financial harm, correct? And I answered, am I not part of the universe?
And on line 14, you stated, again, I am a member of, ... I am a part of the universe, correct?
Yes, I said that.
And if you can turn back to page 40. Line 22.
Yes.
You testified under oath, I think that when people do horrible things to others, that the universe eventually results in them getting what they deserve. Correct?
I said that, yes.
Yes. And so you were in fact acting on behalf of the universe.
No more so than you are now.
Now, Mr. Wade, you were also deposed in 2019, correct?
I was, yes.
And as a part of that deposition, you swore an oath to tell the truth, correct?
I did, yes.
Just like you swore an oath today, correct?
I did, yes.
But during that 2019 deposition, you did lie under oath. didn't you?
Objection, Your Honor. The deposition is only going to impeach, or is only for impeachment purposes.
I mean, that is correct. And I don't know where you're going with this quite yet. I mean, for it to be impeachment, he's got to answer some prior question that then there's something contrary in the deposition. But so I'm not sure what question you're trying to impeach him with yet.
Well, I haven't attempted to use the deposition yet. I was trying to lay some foundation. And
Fair enough.
if he tells the truth, then I'm not using the deposition.
All right, go ahead.
So again, during the 2019 deposition, you lied under oath, didn't you?
That is what you accused me of, yes.
Did the court also determine that?
The court did, yes.
You claimed under oath that you were exchanging emails with the county prosecutor?
I claimed, I don't have it in front of me, but may I go through a timeline of events?
No.
So I had email exchanges and I had a phone call to the prosecutor's office, yes.
Under oath, you were asked if you had any communication with that prosecutor a week prior to, you testified you had communication with the prosecutor within a week of the deposition, correct?
I did, yes.
But this was not true, was it?
I don't know how to answer that correctly because the line of questioning, if I think back to it, I think was interpreted wrong. You had asked if I'd spoken to the
Objection,
prosecutor's
non-responsive.
office.
It's a yes, no question.
It's not a yes or no question.
You can respond.
Okay. Because I think in that deposition, you had asked if I'd spoken to anyone at the prosecutor's office, and I said yes. And then you asked about emails, and I said I had emailed with them. But I don't think it was specifically about Nelson at that time. It had been about John DeWars back then.
Can you turn to Exhibit 6, please? Page 133.
Page 133.
Actually, go backwards. Go to page 130, please.
130 what, sorry?
Page 130. Let's do 131. That's the line of questioning regarding this is done. So 131 of the deposition. Are you there?
Yes.
Okay. And you were asked, line one. Have you spoken to the Kitsap County Prosecutor's Office? Your answer was?
Oh, I'm sorry, I'm looking at the wrong 131. I'm looking at the bold print one. Sorry, one second.
That little one up top, right?
Yes.
You're there now?
Yes.
Okay. And so you were asked, have you spoken to the Kitsap County Prosecutor's Office?
Yes,
And your response was,
I have.
and then I asked, and when did you speak with them?
I said this week.
Okay. And on page 132,
Yes,
on line 2,
yes.
question posed to you, when, ... how did you communicate with her?
I believe before they had asked me about email, and so I said, yes, I had communicated with email. Yes.
And so your answer to that question was with email,
Yeah.
correct? And on line 4, I asked you regarding DeWars or regarding Mr. Nelson or both?
I said DeWars originally, Nelson recently, but before they'd asked me if I'd spoken with anybody at the county, and I said yes.
And the question number 7, you exchanged emails with her?
Yes, I'd exchanged emails with her.
And scroll down to line 22.
Okay.
I asked you, when did this take place?
When did I speak to them? I said it was this week.
The emails.
Um,
We can go line by line.
I know, but this is where the confusion, I think, came in with my answering.
Let's go down the line so
Okay.
maybe it's not.
Originally, you asked me, did I speak with anybody at the prosecutor's office? I said yes. An email is not speaking. An email is written communication. So if you're asking me about when I spoke to someone versus when I emailed someone, the way your questions go in this line seems to be where I got confused, in that if you're asking if I spoke to someone or if I emailed with someone.
Let's review this declaration, or
Okay.
excuse me, deposition. So again, question 7, I asked you, you exchanged emails with her. Your answer was yes.
Yes.
I then asked you, which email address were you using? Your response was the Kitsap County Gov one.
Yeah.
Correct.
Yes, your email, yes.
I then asked you your email address. Your response is, oh. My question to you, which email address? Oh, HoustonWade@gmail.com.
Yes.
I responded, I'm sorry, which one? HoustonWade@gmail, the one I use for everything.
Yes.
Objection, Your Honor. This seems more like testimony. Is there a question?
Your Honor, Mr. Wade is testifying that there was some confusion in this interaction, and so we need to
Go
go through
ahead.
this testimony.
Go ahead. Continue.
And the question was asked, and you said it was with the Kitsap County, you interrupted, but yeah. Then prosecutor's office. Response, yeah. And then I asked, when did this take place?
This
And the
week.
response is this week.
Yeah, that's when I called them, yes.
But all the prior questions were regarding the exchange of emails,
No,
wasn't it?
The first question when you asked if I spoke with them.
And do you recall, prior to the deposition beginning, that you stated to my client that my client was going to be charged with a felony witness tampering if he didn't dismiss the case and pay you $50,000?
I said I was going to have them charged, yes.
And you also made a demand for $50,000?
Yes, for legal costs.
And at this time, you were representing yourself, correct?
Yes.
And it was these statements regarding your communications with the prosecutor's office that was concluded to be a willing and knowing lie under oath by Judge Hauser, correct?
Well, that's what Hauser ruled, yes.
Yes. Now, you received, strike that for a minute. Mr. Wade,
Yes.
you turn to Exhibit 2, please.
Two.
Look at Exhibit 2 and 3. They're kind of coupled together, so I apologize for flipping back and forth. But do you recognize what Exhibit 2 is?
It's one of the admissions or interrogatories you sent, yes.
Okay. And do you recognize what Exhibit 3 is?
Get another set of requests of admissions, yes.
On page, so let's specifically look on Exhibit 3. This is your response to the request for admission. Correct?
Okay.
Is that correct?
Looks like yes.
Okay. And so Exhibit 3 is your response, and Exhibit 2 is the complete request itself.
Yes.
Okay. And if you can turn to page 19 of Exhibit 3, please.
There's numbers. Okay.
Looking on line 9.
Where my signature is?
Yes, that's your, no, that was going to be my question. That's
Okay.
your signature?
Yes.
Okay. So you signed the verification under the penalty of perjury that you had read the foregoing objections and answers and responses to plaintiff William Nelson's second set of requests typo for admission to defendant. Know the contents thereof and believe the same to be true and completed.
Yes.
Yes. Okay. And your responses in Exhibit 3 are the responses to the questions posed in Exhibit 2, correct?
Yes.
Your Honor, we ask that Exhibit 2 and 3 be entered.
And Your Honor, I'm objecting based on all of the objections that I've actually listed in Exhibit 3. Some of these cannot be authenticated.
But isn't that demonstrated by your answers to those? I mean, you've said in some of your answers which ones aren't authentic or can't be authenticated, and so why is that a basis for not admitting the exhibit? If he answers a question the same way he answered it, he's going to say, I don't know what that is, I don't think it's authentic, I didn't post it. He's going to presumably say the same things he said in his answer. So why would it, under what basis would it be excluded?
This is the best evidence. Under the best evidence rule, at least the original needs to be produced, or you need to have somebody who has done the original testify that is the original document and that is a correct copy of the original document. We don't have that here. Some of these posts are not even they're comments to other posts.
Right, but that's how he responds, right? If the question is asked. If I attach a cartoon to a request for admission and you deny it, it's not, evident against your client in any way. I mean, you've raised all these reasons why you didn't admit or deny certain of these things. Presumably, he will testify consistently with that.
Okay.
So yeah, I don't see a best evidence issue here. I'll overrule the objection.
Okay.
Can you turn to Exhibit 2, please? And then within Exhibit 2, Exhibit B, he's a boy. If you can turn to the second page, the one where there's a picture, please.
Yes.
Okay. Do you recognize this?
I do.
Is this a post? First of all, did you post this?
I did.
Okay. And this is your Facebook account?
It is.
And this was posted after the injunction hearing, correct?
Yes.
So while the case was pending?
Yes.
Yes. And the contents of it, I just won the injunction hearing, which means I can write this. William Bill T. Nelson rapes women and abuses children. He's a drunk and a cokehead and is currently facing multiple DUIs and a hit and run. He's a terrible human being, and everyone on earth should avoid him at all costs. Time's up, douchebags of the world. That's
what I wrote, yes.
what you wrote. Okay. If you can turn to Exhibit C, Season Cat. And the third page on that, it's the Twitter post from quote-unquote Rock God.
Yep.
I'm sorry, the letter again?
Season Cat.
Okay.
The third page. Do you recognize this tweet?
I do.
The handle of the tweeter, if you will, or however we want to refer to Twitter now, is at the Houston Wade. Is that correct?
No, it's at the Wooston.
The Houston. My apologies. The Houston Wade. Is that, or was that your Twitter?
Yes.
Okay. So you were the one that was writing this?
Yes.
Okay. And so you tweeted this tweet, correct?
I did, yes.
Okay. And this was tweeted on January 5th of 2019, correct?
I don't know about the date because it doesn't say that on here.
I'm sorry. The copy I have in front of me has the date,
Exhibit C, page
3.
Page 3. Oh, I was looking at the wrong one, I'm sorry.
Or not a problem.
This is the Houston Wade one, yes.
And so, to be clear for the record, the tweet I'm referring to is, I created the Bainbridge Island ad list to spotlight these creeps in my community, currently being sued for $5 million by a pissed off rapist. He's going to lose.
Yes.
And that was tweeted on January 5th of 2019.
Yes.
And again, this was tweeted during the course of litigation.
It was a reply to someone, yes.
Can you turn to Exhibit D, D's and Dog? Can you turn to page 2, please?
Okay.
Do you recognize this, this post?
Yes,
And this was on your personal Facebook page?
it was, yes.
And do you recognize the post specifically from Houston Wade? Yep, Bill Nelson, I worked hard to bankrupt him and finally did. We got the Manor House declared a historic landmark and managed to keep banks from lending to him for years. So when he finally began construction at Pleasant Beach, it was right before the bottom fell out of the economy. He needed to spend millions renovating the Manor House before he was allowed to start building the rest of the development. Do you recognize that?
I do.
Was this a post made by you?
It was made by me, yes.
Let me turn to Exhibit H. H is in Houston.
Okay.
Are you there?
Yes.
Okay. Do you recognize your post on this page?
Yes.
And this was posted on the Real Bainbridge Islanders Facebook group?
It appears so, yes.
And in response to a question from Matt McCullough, you stated it's more talking about a child sex trafficking ring in a public forum and keeping the community aware that these men also drugged and raped dozens, if not hundreds of women and never faced consequences for it. Plus, the litigation isn't long for this world since Nelson keeps threatening witnesses, and then in parentheses you write felonies.
Yes, but Nelson was threatening witnesses.
Mr. Nelson, excuse me, Mr. Wade, you are currently obviously filing for bankruptcy at this time, correct?
Yes.
Okay. Filing for bankruptcy is not good for the individual who files it, correct?
As far as I know, it is not a good thing to have happen now.
It's harmful to them, right?
I mean, it's an inconvenience.
You don't think it's, filing for bankruptcy is harmful for you?
Objection argumentative.
You can answer, overruled.
I mean, it is what it is. I'm not a big user of credit to begin with. So, until this order came about, my discovery of it, my bank account being drawn, I was okay with paying my bills. So
bankruptcy does harm your credit.
well, obviously harm your credit, yes.
Okay. And it harms your ability to obtain loans.
Yes, if I needed some, yeah.
Sure. And you testified that you worked hard to bankrupt Mr. Nelson.
I wrote in a post that I did, yes.
Yes. And so, obviously, that would impact Mr. Nelson's ability to get loans.
Objection, Your Honor. This is asking for like an expert opinion. He's not an expert on how bankruptcy affects somebody after filing.
Your Honor, he just testified moments ago.
He did.
It will impact ability to
Overruled.
obtain a loan.
Yeah, he did testify to that.
Oh, in fact, my ability to get one, yes.
Your Honor, no further questions at this time.
All right. I've got 12:30, and this seems like a natural break, so why don't we take our lunch break now? Let me get a feel for how much longer you think you're going to be, because I don't want to run you out of time. So, Ms. Lane or Ms. Hildman, how long roughly do you think you'll be with Mr. Wade?
Miss Lane is going to do that.
Okay.
Yeah, an hour at most.
All right. Then I don't think we're going to have a lot of time issues. So is an hour for lunch good for everyone?
Yeah, that's good.
All right. It's 12:30. Then we'll be at recess until 1:30.
All rise.
Emailing.
Yeah, is that safe?
All right. Any preliminary matters before we start? No? All right. Mr. Wade, you can return to the stand if you would. Just remind you, you're still under oath. Yes, sir. I'm ready. Thank you.
All right, good afternoon, Mr. Wade. I would like to go back to Plaintiff's Exhibit 2, Exhibit F, as in Frank.
Yes.
you find out about the state court's judgment?
That was in February 2022.
And Exhibit F, if you can look, what is the date on that?
January 30th, 2022.
So you found out about the state court judgment after you had written this post?
Yes.
When you found out about the judgment, did you take down the posts about Mr. Nelson?
I did. Or at least everyone I could find.
And when did you take down the October 4th and the October 21st post about Mr. Nelson?
When I got served for the temporary restraining order.
And when did you get served the restraining order?
That was October 24th, 2018.
And was Mr. Nelson there?
Not the original service, no.
When was he there?
The next day, he attempted to serve me again so he could videotape me being served at work. And then he gave that videotape to Richard Leroy Nearson to post on YouTube.
And then what happened with that video?
Richard Leroy Nearson posts it constantly on Reddit, Twitter, Facebook, and other social media platforms.
And so Mr. Nearson was not there.
He was not.
It was Mr. Nelson who took that video.
Yes, and he was with the man who served me, yes.
And is that video still up?
It is.
And has
So, Ms.
Mr.
St. can I interrupt you for 1 second?
Yes.
The October 24th, 2018 was, what happened on that day?
That's when I was originally
was-
served.
With what?
The temporary restraining order, Bainbridge Police served me.
And the judgment is from what?
So,
Yeah, I'm not following the timeline, and this might be
Okay, so-
important, so I need to get clear on what we're talking about here.
Sure, so would you like me to ask some questions or just explain it?
Why don't you explain it to me first
Okay.
without adding anything new, if you could?
Sure, so-
And if not, then we'll ask him some more questions.
Original post that the state court litigation was about was his personal post at October 4th.
Of
And then-
18, right?
Of
Yeah.
2018, and then on October 21st one of 2000, that was the one on the Bainbridge Island address. And then he was served with a temporary restraining order by Mr. Nelson,
Or by the Bainbridge Police.
by the Bainbridge Police on October 24th.
To what? Take down the same stuff that became the basis for the judgment?
Correct.
All right.
It was just a few.
Yeah, it was just a temporary restraining order to take that down.
It didn't have specifics at that point. Don't believe, right?
All right, well, go ahead.
Yeah.
Just maybe go back through that questioning if
And then
you think
you-
it's important, because I'm not sure I have everything clear on that.
Okay. Let me say it.
Yeah.
Okay, so we're at October 24th. Then what he was just testifying about took place on October 25th, which is when Mr. Nelson was,
Served me the papers again.
well, a process server did.
Yeah, process server did. And Mr.
Served in the
Nelson-
TRO.
Yeah.
Correct.
That's what's
Yeah.
being served.
Yes, right. Sorry, I was trying to say it without embellishing.
And did you go to court for the temporary restraining order?
Twice. First time, Nelson had gotten Kent Bratt as his attorney. Bratt said he needed more time and asked for continuance. Then I went back a second time, and this time they asked for the temporary restraining order to be dismissed and serve me with the lawsuit. It gets up to Superior Court.
And in that temporary restraining order, you had filed a declaration, correct?
I can't remember if I think the declaration was filed against the lawsuit.
Okay. Can you
I can't
turn
remember
to page
exactly.
D7?
He said. Oh, yeah, this is the There was an injunction restraining order hearing in the county court that replaced the municipal court one.
Okay, so just to clarify, the TRO that was served to you on October 24th was dropped.
It was dropped, yes, and replaced with the county suit, or the state suit in the county court.
Okay. And D7, you see the title, can you read the title of this document?
Declaration against motion for temporary restraining order, temporary injunction.
And you wrote this.
I did, yes.
Can you turn to page 7? And we're looking at paragraph 20, which is on line 19.
Okay. Would you like me to read it?
Yes, can you please read that?
I created the Bama John Bad List as a news page to inform the community of who the predators are among us, and Mr. Nelson fits that bill to a T. I didn't stalk Mr. Nelson. I didn't harass him. I wrote an article about his predatory actions, which were confirmed by many, many sources. My goal is to warn people, especially young girls, to stay away from Mr. Nelson for their own safety. The purpose of journalism is to expose abuse, and that is exactly what I've done in this instance, the abuse of women and girls and the abuse of the system designed to serve and protect them.
You'll see at the bottom of these pages, you'll see like D7 in the left-hand
Yes.
corner, and in the middle of the page, you see a page number. Can you turn to page 10 of D7?
Yes.
I mean, this was an exhibit admitted into court, correct?
Yes.
Okay, and this is an email from Ashley Cross DeGrow. You see that in the left-hand corner?
Yes.
Could you please read her email?
Yes, Houston, there are a few stories.
Objection, Your Honor, this is hearsay.
This goes to defendant's state of mind of why he actually created the Bainbridge Island Bad List. We're not stating whether or not what he wrote about is true or false. We're going directly to what the state of mind of Mr. Wade was when he created the Bad List.
If he wants to testify as to his state of mind, that's fine, but
Just hold on one second if you want. Yeah, I'll overrule the objection. I think it's fine. We're talking about his subjective intent here, and it doesn't really matter what the content of this is true or not necessarily. It's the information that he had at the time, whether it was true or not, could be relevant to his intent. So not allowing it for the truth of the matter, but I will allow it.
Mr. Wade, you can please read.
Okay. Houston, here are a few stories I could think of. I hope they help. Bill Nelson is a creep. I met him when I was probably around 13 on a job site with my dad. I was one of the few girls my age that already developed a sizable chest. I was regularly mistaken for 16 at the time, which old creepy men seemed to find acceptable age to hit on me. I remember Bill clearly looking down my shirt, my dad saying something to him like, "Hey, that's my child." My poor dad had no idea what to do with me other than to warn me. Afterwards in the truck on the way home, my dad said to me very seriously, "Stay away from Bill." I've heard my dad say this quite a few times. I'm sure my dad has seen many things happen with Bill. They went to high school together, and I've never heard a good story about him from my dad. I've had quite a few experiences with Bill, and I really can't recall any of them being good. On multiple occasions, I've encountered Bill at the coop, and he shamelessly hit on me, touched me without consent. I can pretty clearly remember one specific time he touched me without asking. There was a resurgence of partying at the chicken coop at some point. This time he clearly grabbed my butt, and his son almost got into a physical fight with him about it. He tried to play it off that we were in a small space, his hand grazed my butt, but at his height, he would have to bend over a fair amount to even get close. On another occasion, he brought a date to my friend's house. We headed over to Bremerton on the boat for dinner. The whole night, he was practically forcing drinks down our throat. It made me, and obviously her, very uncomfortable. She obviously was not having a good time, and he was pushing and pushing her. She miraculously made it back to my friend's without puking off the boat, but did so as soon as we got back. My friend insisted they stay the night, and she just wanted to get away from him. I don't know what ended up happening to her that night, but based on how he was touching her and giving her even more alcohol, anyone could have guessed what happened after I left.
Thank you. And Ashley Cross-DeBroche, she also made a post, or comment, I'm sorry, to your October 4th post.
She did.
And can you turn to page D7, D711?
Yes.
And what is this?
This is,
Same objection, this is hearsay. We have no way to authenticate what this is, where it came from.
No, we can't even see who this document's from, at least in the copy that we have.
This is also going to the state of mind of Mr. Wade. This was already admitted in
Well,
this.
It is, but he's going to have to be able to at least authenticate it and tell us what it is first, because it's not clear from just looking at it. So if he's able to do that, then I would agree with what I said on the prior objection, but you're going to need to start with some foundation on this one.
this is a
Let
DM
her ask you a
Oh,
question.
sorry.
Okay. And do you recognize this document?
I do.
And what is this?
This is a direct message on Facebook from Jared Willett.
Same objection.
To myself, to me.
There's nothing on this exhibit to identify where it came from, who wrote it, or anything.
No, I'll overrule it. I think you can put it in. He's testifying to it.
What's that? If you can just rephrase, who was
So,
this from again?
it's from Jared Willett, a friend of mine's direct message on Facebook.
Can you spell that?
Oh, goodness.
Or at least phonetically or something? Is it a W?
It's
Wolet?
O-O-O-U, I think E-L-E-T-T-E.
All right, close enough.
I could be really wrong on that. It's French. I don't know.
And can you please read?
He sent me a message. It says, "Glad the coop is gone. F those guys. I was dating a girl, showed up there. She was wasted. Nelson had his hand down her pants." And I replied, "I always told them to stay away from there. Some of them did. Some of them had to find out, well, it's supposed to say find out the hard way, but I had a typo. I feel sorry for those ladies."
And when is this document from?
This would have been from October 16th, 2018.
Can you flip to the next page?
Yes.
And do you recognize this document?
Yes.
What is this?
This is a declaration that Ryan Landworth filled out for the municipal court hearing. There's almost a municipal court hearing on Bainbridge for the TRO. that Nelson, I'll give me.
And who is Ryan Landmark?
He is a blacksmith that lives on Bainbridge and a former member of the Bainbridge Fire Department.
And can you please read his letter?
Your Honor,
Yes.
same objection. It's hearsay.
Overruled.
Sometime around 2006, while I was a member of the Bainbridge Island Fire Department, I was invited to attend a party at the Chicken Coop Speakeasy. When I went, it was hosted by Bill Blakely and Bill Nelson. There were other members of the fire department and Bainbridge Police Department off duty that were attending. Shortly after arriving, it was revealed to me that they would be having a stripper that was still a Bainbridge High School student. I was not okay with any aspect of what was happening. I had a child that was a student at BHS. I thought the whole situation was very wrong and would not participate in any way, so I immediately left.
And can you go to the next page, please?
Yes.
Do you recognize this document?
Yes.
What is it?
It's an email Katie Fisher sent to me, and then later she also wrote a declaration for me for the court case, the Superior Court case.
Okay. And can you please read this email?
My name is Katie Fisher, and I met Bill Nelson at a bar in 2012, September, I believe. I've been drinking with friends at Isla Bonita, a bar on Bainbridge Island. I don't remember talking to him much, as he was older than my dad, a good 20 years older than me. After the bar, I remember very little, being in the car and him telling me he was taking me to his home. I remember being in his big master bath jacuzzi, and then brief memory of him on top of me. I came to enough to get a ride home immediately and shrugged the incident off as I was embarrassed. now that I've heard it's happening to other women before, I'm questioning a lot more how and why I would agree to go home with a man my dad's age, et cetera. Anyhow, I hope this stops. I hope he stops.
Now, what is the date of this email?
December 9th, 2018.
Okay, and everything you just read, all the dates are after you had written the article on the Bloomberg Island.
Not the Jerry Roulette one. That was before I posted to, I made the Bamer John bad list. The others were after, yes.
Okay.
Or, one sec. Yes, because actually it was after when I was in the Bamer John Municipal Court.
But all of this information was told to you prior to you.
Yes,
And so this information that you just read was presented to you to help you with the temporary restraining order.
yes.
Will you ask that one again, Ms. Lane?
I'm sorry, pardon me?
I missed exactly the question you asked. Would you ask that question again?
Yes, so all of the information that you just read, it was information that you had prior to writing the Bainbridge Island bad list article.
Yes,
And so the information that you just read from was given to you to help support your declaration in the temporary restraining order.
yes. I believe the Katie Wiedemann one was to help me in the Superior Court. Or Kitty Fisher, as her name is now.
Right, thank you. Going back to the video that Mr. Nelson took of you that is now posted on the internet.
Yes.
Is it posted to a specific website?
It's hosted on YouTube, but it's posted to lots of websites as a link from YouTube.
Okay, what is the name of the link on YouTube?
I don't know the exact name of it, but usually when Ryan posts it, it alludes to the fact that I was sweeping the restaurant at the time I was being served. And so it's usually something like 40-year-old loser sweeping restaurant could serve the lawsuit, things like that.
Okay, and did he create something called Houston Wade Lies?
Yes, it's a Reddit subpage, a subreddit.
And is that still up today?
It is.
And do you have anything to do with that?
No, that's all Richard Lee Renderson.
Were you allowed to make posts during the state court litigation?
I was.
Is that why you posted about the bankruptcy comments that you had testified to earlier?
Yes.
And is that why you posted about not paying a rapist shit?
Yes.
So when you say you're able to post during the lawsuit, do I take it that this TRO just expired at some point, it didn't get renewed or something?
The TRO was dismissed, and then the state court ruled there'd be no injunction on my free speech.
So there's a period during the lawsuit from the expiration of the TRO until the ultimate judgment?
Yeah. Yes, sir. Yes.
Go ahead, Ms. Lane.
Thank you. So I want to move on to that bankruptcy comment about Mr. Nelson. How did you bankrupt him?
I was not ultimately responsible for bankrupting him, no.
So then why did you post that?
Bravado, or thinking that I had some small part in it.
And what was that small part?
The fact that I had been approached by Katie Wynio and asked about Bill Nelson, and I told her everything I knew.
Okay, and then you testified earlier, you read from the deposition that eventually Mr. Nelson was denied a loan by Ms. Wynio.
He was, yes.
Do you know the parameters that Ms. Wynio used at her bank to approve or disapprove a loan for Mr. Nelson?
I do not.
And earlier, Mrs. Savagny asked if you wanted Mr. Nelson punished, and you said you wanted him charged, correct?
Yes.
And what do you mean by you wanted him charged?
I would hope that our legal justice system would work in a way that men who hurt women and children face legal consequences for these actions.
Okay. And then earlier, you had also read from your October 2019 deposition. Strike that. Earlier, you had testified that prior to your October 2019 deposition, that you had told Mr. Nelson that he was going to be charged, and opposing counsel was demanded $50,000. Why do you believe Mr. Nelson was going to be charged?
The woman I spoke to at the prosecutor's office and my conversations with the police investigator and the FBI investigator.
And do you know who you spoke with at the prosecutor's office?
I assumed it was Cassie Stokes
And why did you assume that?
because it was the phone number as a footer on her email.
And then one thing that actually was not asked you earlier today when you first took the stand is, where do you live?
Bainbridge Island, Washington.
And how long have you lived on Bainbridge Island?
My entire life, save for a few years in college.
And what do you do for a living?
I work at Bruciato, a restaurant. I'm also adjunct faculty at Edmonds College and the Seattle Film Institute, and I have a YouTube channel.
And how many classes on average do you teach a year?
About 3.
And then why did you start the YouTube channel?
During the pandemic, I had gone viral on Twitter with a thread that was explaining the GameStop stock squeeze, kind of in layman's terms. And I was asked to be interviewed by a gentleman in Northern Ireland who had a podcast to sort of go over that Twitter thread again. And that went super viral. And I was invited to a couple more podcasts, which also went viral. And somebody ultimately, who enjoyed hearing me talk, asked me to make my own YouTube channel. So I did. And it was a great way to connect with people when locked at home during COVID, and allowed me to discuss topics that interest me.
Okay, so the videos that went viral, they were on topics that you have knowledge about.
Yes.
And what is the name of your YouTube channel?
Houston, we have a problem.
And do you have a mission statement for that channel?
Yes, it's more of a question that I answer. I ask, did we create society to make everyone's lives better, or did we create society to maximize profit and drive revenue? I believe in the former.
And what was your purpose to start the YouTube channel?
Originally, it was sort of to identify problems in society and then address ways we can fix those problems, things like healthcare or criminal justice or mental health, things like that.
Okay, what makes you think you have the answer to society's problems?
It's not so much that I think I have the answer any more than anyone else does, but it's a way that we can sort of flush out the problems, the systemic ones, and sort of the, I guess you'd say, the symptoms of them and how we can fix them.
So why does your answer matter?
Sometimes I have an answer, and sometimes it's a great way to, and someone else might have one, and we can discuss it.
So what brings you here today sitting on the stand?
Ultimately, the lawsuit Bill Nelson brought against me in Superior Court.
Did anybody else sue you?
Yes,
And who was that?
John DeWars.
And what happened in that case?
Originally, he filed a temporary restraining order, same as Bill Nelson, in the Bainbridge Island Municipal Court. And at that hearing, his restraining order was denied. And then 2 years later, he sued me for defamation in Kitsap County Superior Court. And that case was dismissed, and I signed a confidential settlement agreement.
Can you walk me through how the Bainbridge Island bad list came about?
Well, in September, October 2018 was when the Brett Kavanaugh hearing was happening in the Senate, and Christine Blasey Ford was being criticized for coming forward 35 years after the fact from when she claimed Brett Kavanaugh had assaulted her. And people were asking, well, why'd she wait so long, et cetera. And I had an example of an incident I knew about where a woman escaped her rapist, ran next door to the neighbors. They helped her, called the police. When the police came, they chatted with her rapist, and then nothing ever happened. And I wanted to demonstrate that It doesn't matter if you wait 35 years or if you report it the moment it happens. Oftentimes, the criminal justice system will fail you. Under that post I made, numerous women were responding that similar instances had happened to them. They had similar awful experiences with the criminal justice system and seeking justice. Ultimately, people asked who the man I was talking about, and I said it was Bill Nelson. And from that point forward, people then started talking about their own experiences with Bill Nelson, how terrible he is, and it led from there. Such as, then I got messages like from Jerry Roulette confirming incidents as well. That is juxtaposed with another incident that happened on Bainbridge around the same time, where a man assaulted a teenager at a coffee bar, and there were comments happening on community pages on Facebook. And ultimately, I decided enough's enough. Like, we can't keep quiet about this stuff. And so I created the Bainbridge Island Bad List to warn everyone about these men who get away with these things in our community.
And did you yourself actually experience, and did you, I'm sorry, strike that. Did you yourself see Mr. Nelson doing anything that you posted about?
Yes. When I was a child, I lived in the Olympian condominiums, and Ginger Larson, who became Nelson's wife, lived upstairs with her children from us, and his daughter Audrey was my best friend. When Nelson started dating Ginger, my mom said I was no longer allowed to go to Audrey's house anymore. That she was allowed to come to our house, but I couldn't go over there anymore, and that was due to abuse that Audrey and her family were experiencing. Later, when I was in high school, I was at a party after the Tolo dance, and at house party, and Mr. Nelson arrived with cocaine and tried to force himself on an unconscious girl who was asleep on a couch, when myself and other boys who were in attendance forced him out of there.
Thank you. And did you create a mission statement for the Bainbridge Island Bad List?
I did.
What was that mission statement?
It was, here at the Bainbridge Island Bad List, our goal is to let you know who the worst of our neighbors are. We think you should know who the rapists, abusers, and creeps are, so that you can protect yourself and your loved ones with knowledge.
Thank you. Can you please turn to Exhibit D6? And this has already been submitted into evidence. This is the answer that you wrote to the complaint in Kitsap Superior Court, correct?
Yes.
And this is the answer, more specifically, to the complaint that Mr. Nelson filed against you.
Yes.
If you can be looking on D6, page 1, we're looking at line number 26, the last sentence to that paragraph.
Okay. Mr. Wade alleges that Mr. Nelson does not have enough positive regard in the community for his character to be defamed.
Okay, thank you. 1 second. No. Oh. Can you turn to D6, page 2? And we're looking at line number 25.
Okay.
Can you read that last sentence?
Mr. Wade alleges that the comments made under his post about Mr. Nelson confirms the already existing negative opinion of Mr. Nelson by the community. And many of the comments confirm Mr. Nelson's predilection for underage girls, drinking to excess, and repeated sexual assault.
And can you turn to D6, page 3? And starting the first sentence of the very first paragraph on that page, starting on
Answering the allegations of paragraph 7 of the complaint herein, Mr. Wade denies that he has encouraged others to be vindictive towards Mr. Nelson. Mr. Wade alleges that he, oh, sorry.
I just wanted to read
Oh,
that.
okay.
D6, page 4, line number 25, that last sentence.
Mr. Wade alleges that a large portion of the population of Bainbridge Island already hold Mr. Nelson's reputation in an overwhelmingly negative light, and Mr. Nelson does not have a good name to tarnish.
D6, number 5. Looking at line number 5, that the sentence that starts on line number 5 and it ends on line number 8.
Okay. Mr. Wade denies any damage to Mr. Nelson's reputation. It's the fault of Mr. Wade. Mr. Wade alleges that any negative reputation of consequence Mr. Nelson encounters is due to Mr. Nelson's predatory behavior and overuse of drugs and alcohol.
Thank you. And just 1 second.
Let me see.
That is it. Thank you.
All right, go ahead.
Thank you, Your Honor. Mr. Wade, can you turn to Exhibit 2, subsection Exhibit D?
Is that plaintiff's exhibit?
Plaintiff, yes.
Which letter to what?
2.
Letter.
Plaintiff's Exhibit 2, subsection D. Is gone. This was the first post that you made about Mr. Nelson, correct?
Yes.
And this was prior to October 16th, correct?
It was. I believe it was October 4th. The date's not on here.
October 4th. Okay. And you said you were served with the TRO when?
That had been October 24th.
So turning back to Defendant's Exhibit D7. Going to page 11.
Yes.
That, you're alleging, is a response after the post that we've just referred to in Plaintiff's Exhibit 2.
Yes.
Okay. Similarly, we turn to page 10 of D7, so the page before.
Yep.
That's dated November 8th,
Yes.
okay? And page 12, that letter is dated November 30th.
Yes.
And the email on page 13, that's dated December.
1 second, let me catch up with you.
Sure.
I missed the last one.
I'll get that for the court, Your Honor. So
I got page 11, page 10, and then where did you go after that?
then we went to page 12.
Page 12.
And that letter is dated November 30th
The one on
on
Yeah,
page
page
12.
12.
yes, yes.
And then moving on to page 13, that email is dated December 9th.
Yes.
Correct.
Yes.
And none of these documents in Exhibit D7 on page 10, 11, 12, or 13, none of them are signed under penalty of perjury, correct?
They're not, but Katie Weedman did fill out a declaration for the case later.
But this email is not correct.
No.
And in fact, aside from page 11, every single one of these was sent after you had been sent the TRO, correct? Correct.
No. Because Jerry Willett sent his before.
Which one's Jerry Willett?
The one on 11, yeah, sorry, 11.
Yeah, I said besides
That's
11.
right. Sorry.
So besides 11, so page 10, 12, and 13, all of those were sent to you after the TRO.
Yes.
And all of them were sent, in fact, because of the TRO, because of litigation.
Yes.
So at the time of your first post about Mr. Nelson, none of these corroborating claims that you're pointing to were in your possession.
Well, I mean, Ashley Cross DeGrow had commented on the posts corroborating that.
But obviously, your post came first, and then a response came afterwards, correct?
Yes, because I'd asked some of them to send me something.
So at the time of the post, you didn't have these supposed stories from individuals.
Oh, I had the stories, just not in a written form.
Going back to Exhibit 2,
Plaintiff or defendant?
I'm sorry, what?
Which plaintiffs or defendants?
Plaintiffs. And then Exhibit D within that.
Mm-hmm.
In this post, you state that years ago, a connected alcoholic Republican politician / real estate developer raped my friend's daughter in Fort Worth. She escaped and ran naked to the door of the neighbors, who happened to be another friend of mine, screaming for help. They took her in and called the police. When the cops arrived, they shook hands with the rapist and joked with him for some time and then left. No arrests, no charges, no taking the victim for a medical exam or rape kit, nothing. You did not observe this, correct?
I did not observe it, no.
And none of the posts or letters that you received are from a witness of this?
No.
And this claim was ruled defamation by Judge Hauser, correct?
Yes, it was.
Okay, I'm sorry, could you go back to your immediate prior question? Basically two back, not the one you just asked.
None of the responsive posts or letters were from witnesses of this
Of that
allegation.
action. And how did you answer?
No.
Okay. You go ahead.
Moving to the second page, so just the following page.
Yes.
This is the post that you identified Mr. Nelson, correct?
It's the comments, yes. I identified Mr. Nelson, and yes.
And this is where you stated, I worked hard to bankrupt him and finally did, correct?
Yes.
Now, you've claimed that that's bravado speaking.
Yes.
So is that your way of saying that you lied,
No. Embellished, maybe.
embellished?
Yeah.
So you didn't, in fact, bankrupt him?
I wasn't the one who bankrupted him, no.
No, but you said you did.
Well, it's subjective in the phrasing I use. Maybe hubris.
And going back to the first page, still on Exhibit D, the woman you're referring to that supposedly was raped, who was that?
That's Elizabeth Kaltwriter.
And you never posted, either here or in any of your follow-up posts, that in fact Mr. Nelson had to get a restraining order against her, did you?
I did not post that, no. I never found a restraining order against her.
Did you look?
I did.
Objection relevance?
Yeah, I think it's relevant, overruled.
Yeah.
So you looked, but you couldn't find it?
Yes, I looked, I couldn't find it.
But you were able to find records regarding Mr. Nelson.
Yes.
Would you say you're good at research?
I'm adequate.
You're adequate.
I don't know how to search for everything, but I can find some things.
Okay.
Could you just repeat who that woman's last name is we're talking
Oh,
about?
Kaltwriter.
Cult?
Yes, Kaltreider.
Thank you. Yep.
And did you ever do any research to see if Mr. Nelson had ever been arrested or charged with any type of sexual assault case?
I did search as well, yes.
And?
And he had not been arrested or charged.
No. And did you tell that to your followers as well?
No, the entire point of the article was to point out where the criminal justice system has failed us.
Did you look to see if anyone had filed a rape complaint against him?
No, it did not.
No, you didn't. And did you look to see if anyone had sued Mr. Nelson for rape or sexual assault?
I did not find anything on it either, no.
No. And so did you tell your followers about that as well?
No.
No further questions, Your Honor.
Ms. Lane, any further questions for this witness?
Yes, I do.
Okay, just 1 second, please. All right, go ahead when you're ready.
Just 1 second, Your Honor.
Yeah.
Your Honor, while we're waiting for counsel, can we have a bathroom break after the conclusion of Mr. Wade?
Yes.
Thank you.
So wait, how did you know of the alleged rape?
Troy Dentman told me all about it.
Who's Troy Dentman?
He was the neighbor that Elizabeth Cutwater had ran into for help. And he was my roommate for a period of time.
Sorry, again, I'm not good at catching these names.
Oh, Troy Dentman.
Detman. All right, thank you.
Dettman.
And how
And then-
was it?
Whoops.
Sorry.
Oh, sorry.
I'm still just trying to make sure I got your answer.
Yeah.
So you heard about it from him, and
Yes.
then what was your relationship with
He,
him? Or?
he was the person Elizabeth Cutwater had run to for help, and he was my roommate for a period of time.
So you're saying she ran to his house or
Yes.
his parents' house?
Well, his and his wife's house at the time.
Go ahead, thank you.
When was this told you?
This would have been probably around 2011 or so.
How was it disclosed that it was Elizabeth Cultridge was the alleged victim of the rape?
A cult writer.
Sorry.
Troy named her, and then later her.
Object, this is hearsay, Your Honor. I can tell they're trying to craft their questions in such a manner to get around it, but this is an out-of-court statement.
So it still goes to Mr. Wade's state of mind.
Yeah, I agree. I still agree with that. I mean, I'll overrule it. I don't think the truth of these things really matter when we're dealing with subjective intent, so I'll let you ask the question.
Okay. Did you ever use Elizabeth's name in any of the posts?
I'm not in the post now.
So how did her name become known as the alleged victim?
In the original TRO, Mr. Nelson named her.
So you did not name her?
I did not name her, no.
All right, thank you. That's it.
Any further questions?
Very quickly, Your Honor.
Sure.
Who was the individual again that allegedly told you this story?
Well, two people did. First one was Troy Dentman.
Troy Dentman.
Yes.
And he didn't submit a declaration in the underlying case, did he?
He didn't have a chance, no.
No, he didn't. Didn't have a chance?
Yeah.
Okay. But litigation was going on for how many months?
Sometime, yes.
Sometime, okay.
I was hoping to depose him.
Sure. And on the post in Exhibit D, plaintiff Exhibit 2, subsection D as in dog.
Yes.
No, it said subsection D.
In that post, so second paragraph, you said years later in the middle of the night, she phoned her 13-year-old son and said her goodbyes and then jumped from the Agate Pass Bridge.
Yes.
That's a pretty detailed note about the individual.
Yes.
So there was not any confusion as to who you're referring to, was there?
If you knew the situation, you'd probably know exactly who I was talking about.
Nothing further.
Ms. Lane, anything further?
No, Your Honor.
All right, Mr. Wade, you can step down. Thank you. So we'll take a break in just a second, but tell me where we go from here. Are you going to recall Mr. Nelson? Does either party want to recall Mr. Nelson?
Smith, quick.
Yep, go ahead.
Thank you. We will not be recalling him, Your Honor.
All right, Mr. Savaggi?
No, Your Honor.
All right, so anyone have any other evidence they want to put in, or are we just down to closing arguments? Just closing?
I think closing, Your Honor.
Ms. Lane, just closing?
Closing.
All right, then let me give you a little bit of time, and we have time, so why don't I work off of you? How long of a break would you like to gather your thoughts and put together your closing?
Your Honor, if you can have 30 minutes.
That's fine.
All right, so I've got 2:25. Why don't I give you 35 minutes? We'll do closing at 3 o'clock. Sure. All right, be at recess. Thank you.
All rise. All rise.
Please have a seat. Thank you. All right, closing, plaintiffs.
Thank you, Your Honor. Again, Paul Frazier for the record. Represent the plaintiff, Mr. William Nelson. I think it's important to remember that a discharge in bankruptcy is a privilege and not a right, and it should only inure to the benefit of an honest debtor. And what we have here is a dishonest debtor. Mr. Wade has admitted under oath that he lied under oath. And the Kitsap County Superior Court determined in its order that Mr. Wade lied under oath. We only need to show that by a preponderance of the evidence, meaning that it's more probable than not, that Mr. Wade must have actually known when making these statements that injury was substantially certain to occur. We don't need to establish or get an unqualified admission from Mr. Wade. If that was the case, then it would be nearly impossible to accept a debt from discharge. The willful the willfulness element is satisfied when the natural consequences of the debtor's actions are substantially certain to cause injury. And there is a presumption that the debtor knows the natural consequences of his actions. We have already established as a matter of law that the statements that were published online by Mr. Wade were false. We have established that they were malicious. We have established that they caused injury. So we only need to establish, again, by a preponderance of the evidence, that when those statements were made online repeatedly, that Mr. Wade should have known that they were substantially certain to cause injury. And again, they've already been determined to be false. It would be nearly impossible for any reasonable human to believe that false allegations of sexual assault made online would not be substantially certain to cause injury, or would not be likely to cause injury. And while the story testified to in court today by Mr. Wade is that he was trying to protect the community and to report claimed bad actors on Bainbridge Island, that story just doesn't hold water. Mr. Wade testified under oath that he intended to cause Mr. Nelson's bankruptcy, and in fact testified that, and in fact bragged that he caused Mr. Nelson's bankruptcy. So this had nothing to do with protecting the community. This was a targeted attack to cause and inflict as much, reputational and financial harm as Mr. Wade could possibly inflict through publishing these false allegations on social media. Now, significantly, there was not a single witness or sworn statement, under oath presented by Mr. Wade to corroborate anything that he has said. Not one. Mr. Wade did not attempt to introduce into evidence any sworn testimony by any independent witness. There was not a single exhibit admitted into evidence by Mr. Wade attempting to support the truth of the allegations that he made. All we have are hearsay, out-of-court statements, not sworn under the penalty of perjury, and there are reasons we have, rules of evidence. There's no one here to back up anything that's been said. Mr. Wade himself admitted that he did not find any corroborating evidence to support the allegations that he made. He claims that, he says he is a proficient researcher online. He did not locate any criminal proceedings, any civil proceedings supporting his allegations of rape. Yet he states that as fact over and over and over again online. What this was a social media lynch mob designed to destroy and defame Mr. Nelson. And none of that lynch mob has never stood behind anything they've said. They had, this has been in litigation for 5 years, since 2018. And if there was anyone to corroborate, again, any of these statements about Mr. Nelson, they had 5 years to come forward with a sworn declaration. Mr. Wade had the opportunity to depose them or to have them testify in court in his favor. And it's been 5 years of complete and utter silence. Mr. Wade admitted through requests for admissions that he made all of these statements that have been alleged. Plaintiff's exhibits number 2 and 3 were admitted into evidence, and specifically Exhibit B, Exhibit C, Exhibit F, and Exhibit H. Mr. Wade admitted to posting online. So there is no question that this stuff and these defamatory remarks were made. They've been introduced into evidence. He does not dispute making them. And similarly, he does not dispute the damage that they caused. Again, Mr. Wade concedes and admits that he was targeting Mr. Nelson, that he loathes Mr. Nelson, that he hates Mr. Nelson, and that he was purposefully intending to injure Mr. Nelson. There is no dispute about that. And this is all stemming from, and I'll quote the Superior Court, wild allegations that have no basis in reality. So when you make wild allegations that have no basis in reality online repeatedly about falsely accusing someone of sexual assault, it's more probable than not that that is substantially certain to cause injury. And again, there's no dispute that these allegations were made. There's no dispute that Mr. Wade made them. And even in his deposition, he talked about karma and about karma being part of the universe, coming back to, exact retribution and pay people back for, alleged wrongdoings. And Mr. Wade, he believes he is the universe. That's what he stated in his deposition. I mean, his Twitter handle is Rock God, and he stated that he thinks he has the answers to cure all of society's ills. So he himself believes that he is like a god, essentially. He is out here to exact punishment on individuals who he himself, believes should be punished. And that's what he was attempting to do here. This was not about the community. If this was about the community, these would have been objective facts supported by actual evidence, not wholly uncorroborated, again, wild allegations that have no basis in reality. And I think we've probably all read the news enough to know that wild allegations of sexual assault that have no basis in reality actually do more harm than good. They don't help the community. In fact, all they do is tend to undermine what actual victims of sexual assault are trying to accomplish, which is to have someone believe them. So any claim that Mr. Wade was attempting to help the community is just simply not true, and it cannot be true as a matter of law based on the findings in fact and conclusions of law in the Superior Court judgment. So again, the low burden of proof here is a preponderance of the evidence. It's whether or not the debtors actually knew that injury was substantially certain to occur. And it is more probable than not that wild allegations of sexual assault having no basis in reality, repeatedly published on social media, would tend to cause, or would be substantially certain to cause injury. And for that reason, Your Honor, we ask that Your Honor find that this debt be accepted from discharge for willful and malicious injury.
All right, very well, thank you.
Thank you, Your Honor.
All right, defendants?
Thank you. I need to move my computer, it will die on me.
Let's do the curse of technology.
Yeah. It's all right, we'll work it out.
Wade can't support any attack on the facts because the very order that they have argued successfully is intact. This court has made that clear. But now we are here to discuss one little prong of 523A6, the willfulness prong. Here are the facts. Mr. Wade testified that Mr. Nelson personally took video of a process server serving Mr. Wade, and Mr. Reinerson got the video. But under oath, Nelson said he doesn't have any meaningful relationship with Mr. Reinerson except for encouraging emails. Nelson said Wade made these accusations out of thin air. But Nelson testified he was charged with 4 DUIs, including a hit and run, and his ex-wife filed a domestic violence restraining order and made specific allegations of violence and threats against Mr. Nelson. This is all public record and happened prior to the Bainbridge Island bad list. He also testified his 4th DUI was in 2018. Mr. Wade testified he witnessed a sexual assault by Mr. Nelson years prior to the Bainbridge Island bad list being created, and this is unrefuted. Mr. Nelson admitted the use of cocaine. Let's remember he supposedly doesn't remember which substance he was under when charged with his first 2 DUIs. When Ms. Hulsman asked if he was ever arrested for assault, Nelson said he couldn't recollect. While I'm pointing out problems with the truth Mr. Nelson had on the stand, we're here today to determine Mr. Wade's subjective intent. A dishonest debtor relates to a debtor that has lied on their schedules. Wade is not a dishonest debtor. The basis for Mr. Wade's beliefs are substantiated here. Nelson testified that some of the negative comments on the October 4th post, which is Defendant's Exhibit 2, were people he knows. The only evidence the plaintiff has submitted is their Exhibit P1, the findings and facts and conclusions of law that Wade's intent was to run Nelson off the island. Nelson testified he is still living on Bainbridge Island and still has his business there. Nelson also testified that he was scared to go in public after the Bainbridge Island post. However, he went out in public and filmed Mr. Wade on October 25th, and this is unrefuted, and submitted that video to Mr. Reinerson to post for him. However, Nelson acted on the stand that he barely knew Mr. Reinerson. Nowhere did Wade say he published the statements with the intent to harm Nelson. Wade has maintained through the state court in this action his intent was to protect the community. This is reiterated in Wade's answer to the state court complaint. This is Exhibit D6. This is in line with the mission statement for the Bainbridge Island bad list that Wade testified to on the stand: to protect yourself and your loved ones with knowledge. Nelson's reputation is a -1. This again is unrefuted. His reputation did not become negative because of Wade's comments. It's quite the opposite. Many people in the community already had a negative view of Nelson prior to any of the posts Wade made. Putting it simply, Your Honor, the plaintiffs have not met their burden. Thank you.
Thank you. All right, so that will conclude the trial. Record is closed. And so I just need to check with your schedules and set a time to rule. It can all be telephonic because I'll be the only one talking that day, but your clients are welcome to call in addition to the lawyers. And so let's find a time in the not too distant future to do this. I need a little bit of time to prepare. How would September 29th work for the parties? Either at 11:30 or in the afternoon?
11:30 worked really well for me after daughter's nap time.
All right.
Looks right. I'm probably going to end up being in the hearing on that day. Okay. So if you're available. Yeah.
As long as at least one of you.
Yes.
I need at least one of you.
I think 11:30 works fine. I think I'm going to be in the hearing, but
All right, let's do that.
Frederick will be available.
You know, and it'll eventually be on the docket, probably by the end of the day, if you want to go back and listen to it.
Will do.
So let's set, oral ruling on the trial will be set for September 29th at 11:30. My guess is it won't take in no more than 30 minutes probably, just for your planning purposes. If for any reason I'm not ready to go, I'll have my chambers give you a call a couple days ahead of time and we'll reschedule, but I fully anticipate that I will be ready to rule. So we will enter a docket entry indicating that the court will issue its ruling September 29th at 11:30. And just a day or two before, if you want to call chambers to make sure you have the current proper phone information. We do change the passcode pretty often. And with that, we'll wrap up today. I want to thank everyone. I thought everyone acted professionally in what can be a stressful environment, particularly considering the subject matter of some of the testimony today. So I appreciate that from everyone. And now we will be at recess. Thank you.
All rise.